Well, hello, everybody. Welcome to New Mexico. And welcome back to your favorite show on the internet, Raw Law Unfiltered, with your favorite host, the DUI Guy. Plus, today we are going to start streaming the Alec Baldwin jury trial in New Mexico, Los Estados Unidos, in America. Folks, court has literally just started, and the sound is atrocious. Court TV better fix that. And it's coming out of one microphone, one head earbud or whatever, and it's so bad. Listen to this.
For the avoidance of doubt, Summer Green is a member of the defense team who will provide the defense with real-time and transcripts so as to avoid burdening the court staff.
Okay, they fixed it a little bit.
So,
but it's still only coming out of my right ear.
That she is going to be the official record.
Understood, John.
So, thank you so much, but you're going to have to move.
I've been requested by the state also to provide real time.
There, that's what she said. So, she's asking for real time. That's up to the defense whether they're going to give you real time.
So we, I think both sides are
here we go.
using Ms. Green when we realized that she'd been hired by the defense. We wanted the real time also, just to even the instruments here. If Ms. Green needs a place to sit, she's welcome to sit over here. I agree with the court. The official record is
That means that all the exhibits go through Faith.
Absolutely.
All right. So at the end of the day, she collects the exhibits.
Let's see if we can find Chandler.
I'm sorry, David. All right. So if you don't mind moving, this is optics, and that's how it's going to be. I'm sorry. And then so all right, I'll let you do it today, but tomorrow, yes, okay.
The sound is a little better, but it's still
All
a
right,
little
so
wonky.
let me hear from you all on what I'm prepared to do is hear the motion on excluding late filed witnesses and then going into the motions in limine.
All right,
We can do
exclusion of late filed
state
witnesses. So if any
defense,
witnesses
state
have been
defense.
said,
What do you all want to do?
this person is going to testify, defense is going to move probably to exclude them.
Will be far shorter, and some of these issues, I think, have somewhat been dealt with this briefing, because as much time today as can be spent on things to make sure we have an orderly and good trial, I think are helpful. And some of those were raised.
No closed captioning available.
Not. So that's a fine system, and we're going to hope, at least on the defense side, to move quickly.
Okay. All right, so let's take up. Okay, State of New Mexico's amended expedited motion to exclude defense witnesses Ryan Winterstern and Christopher Zook. You can use the lectern or you can, yes.
You might want to turn that microphone on.
Let me see if I can.
And just so you know, so everybody knows.
If you have a green light, that means put microphones on, if you don't want anybody to hear what you're saying. Yes. State filed this motion on June 26, 2024, after the defense disclosed on June 24th.
Wait, I paused it. Where's it playing from?
And I understand one of the producers.
Oh my God.
Winterstern had not.
It's playing on my phone. I was wondering what that was. Okay, hold on.
No idea
Here we go.
what he is going to be
Court
testifying
TVs is
about,
better.
or any previous statements that he made relating to this particular
But still no
case.
closed captioning.
Setting Gutierrez trial aside, the issue is, what is he going to say in this case?
Here we go.
And because of the late nature of this disclosure, we'd ask that the court exclude Mr. Winterstern. With regard to Mr.
Thank you, folks.
Zook, now while the defense is right, the state did not request pretrial interviews of law enforcement witnesses. They were made available. Mr. Zook was set for a pretrial interview, but apparently he has left the sheriff's department. So the defense canceled his subpoena and did not proceed with the
Hey, there's
pretrial interview.
Chandler.
So he was not
Isn't that
interviewed.
Chandler?
We would respectfully ask that because of
Right there.
the fact that the state has not interviewed these
Behind this guy.
witnesses, and particularly Mr. Winterstern,
Looks like
was
her.
disclosed so late in the game, we ask that the court exclude these witnesses. And unless the court has any questions, Your Honor, we rest on the
My
motion.
girlfriend's in the courtroom. Isn't that the
The
best?
court does not. Thank you.
Thank you.
Good morning, Your Honor.
Yeah, she's wearing a white jacket.
So we'll start first with Christopher Zook. As the state has already conceded, the state did not actually request a pretrial interview of Mr. Zook. It is something that they do have to request. The defense did set up an interview that was for our own benefit. We did inform the state that we had set the interview so that as a courtesy, they could come if they wanted to, but it was not something that they requested. And if the party does not request the interview, then it is deemed waived. And at any point, they had an opportunity to do so. I do have an exhibit to provide to the court. I also have a copy for the state. And so I do have an exhibit A, which is to this motion, if I may approach, Your Honor.
But I don't remember. I thought she forgot her glasses.
And what I've presented the court with is a series of emails that were exchanged between the parties.
Okay, maybe it's not
And
her.
these begin with
What
the
the hell was
request
she
that the
wearing?
state made
I don't
for,
remember what she
witnesses
I only
in
remember
this
what she was
case.
not wearing.
And as the court
Giggity.
can see, and as the state has already conceded, Mr. Zook is absent.
Pretty sure it's a
from
white
their
jacket, though.
request. Now, the reason we've included these additional emails as well is because there were multiple occasions on which the defense actually asked the state if they wanted to amend or add any additional witnesses for whom they wanted to request pretrial interviews. At no time did the state then change their mind and say, yes, we want to interview Mr. Zook. And so that was deemed waived, Your Honor. And we canceled the pretrial interview that we had set for our own benefit for our own reasons. And so the state cannot now seek to exclude him when they did not take advantage of the process that was available to him.
I see. Okay.
Additionally, with respect to Ryan Winterstern, it is somewhat ironic that in their motion, the state claims that the defense recently added Mr. Winterstern to gain some sort of tactical advantage.
No, that's
When really
that's
what
not
we
her.
have here is
Her
bad
hair was
type
not
of
in a
behavior
bun
on
unless
the
she
part
put
of
it in
the
a bun.
state. And one of the ways that we
Bloody
see
hell.
this,
I can't
is
even reach out to her.
that,
No cell phones are not allowed in the
with
courtroom.
respect to the initial filings before there was a dismissal in this case, when the case was originally brought before the court against Mr. Baldwin, originally it had been clear that the previous prosecution team had intended to produce and to pursue a theory that involved liability based on a producer theory on Mr. Baldwin's alleged role as a producer. Based on that, we also then had a conversation with the new prosecution when they took over through Ms. Morrissey. And a conversation was had about the producer theory. And that was gone into in-depth and private conversations, at which point in time, Ms. Morrissey indicated that she did not believe that that had that could hold any water, that it was a viable theory. Later, certainly there was the grand jury presentation. Now, there was really not much of anything related to
that better?
Mr. Baldwin being a producer. They didn't call anyone who was on the set. There were a number of different producers. I believe it was 6 different producers who were actually.
No, I'm a guy. The
on
minute
rest
they
set. They didn't
leave
call
my
a single
purview,
one,
like if I'm not having
to
eyes on her, I
testify.
don't know what she looks like anymore.
And so it was not clear to the defense. And the fact that it was unclear to the defense is apparent in the fact that we have an additional exhibit.
I have to
Your
have
Honor,
eyes on her. If I
may
don't have
approach.
if I don't have her in my immediate vicinity, then I have absolutely no idea what my girlfriend looks like. I'm sorry.
And the exhibit that I've just now handed to the court, which would be then exhibit B to this response, is an email
only playing out of one
correspondence
headphone.
between, again, the state and the defense, wherein, as the court can see,
No, she does not. She wears glasses, but she
and I
forgot her
think the
glasses.
court will have to flip to the back page to see the beginning of the chain. And so on November 1st of 2023,
I messaged her on
the defense
Twitter.
inquires and says, your target notice identifies 2 involuntary manslaughter charges on which you will be presenting information to the grand jury. We then proceed to ask that in order to ensure that the alert letter that we submit
This is one of
actually is
Baldwin's
sufficient,
lawyers.
that we
Yes.
don't waste everyone's time, that they identify the 2 theories that they're going to be proceeding on. The state through Ms. Morrissey then responded, basically just reciting the statute. We then asked and followed up on that to say, we assume that the producer theory is not going to have merit, and so you're not proceeding under that theory. There was no response. The state easily could have responded, could have let us know. They knew where our mind was. They knew that we were thinking, because of the prior conversations that we had with Ms. Morrissey, that this was not a theory that they were going to proceed under. Additionally, Your Honor, with respect to the witnesses that they've listed in the actual case itself, and this again goes beyond just the grand jury. In the case itself, the state has not listed a single one of the producers who were on the Rust film, not a single one. And so at this point, they have 3 different individuals who they're going to call to try to have them testify about what Mr. Baldwin's role as a producer would be on this film, what responsibilities he would have. 2 of those individuals have never been a producer before, and the other individual has very limited experience and was not actually on this set. So we sought, after the state had then disclosed, basically for the first time to us, their intent to proceed under this additional theory through some of the motion practice when we filed a motion related to one of their witnesses. They then first identified that they were going to move under this new theory. So we then, just a matter of days later, added Mr. Winterstern to the witness list, and it was for the first time. But this was because the defense was not on notice that they had intended to pursue this theory. And he was not on the witness list to try to gain some kind of tactical advantage. It was because he wasn't relevant due to anything previously that we understood the case to be about, which was, again, according to the indictment as well, it specifically lists the date of being October 21st, 2021. It does not list a series of dates. It doesn't list the length of time that Mr. Baldwin was on set. It lists one particular date. And so Mr. Winterstern was not relevant to the defense theory at that time. However, now we have added Mr. Winterstern, and the state cannot claim prejudice because Mr. Winterstern was a witness in Hannah's trial, and I'm almost finished, Your Honor. But not only that, he was the state's witness.
This judge has a lot
And
of
they
patience,
did
by the
conduct a
way,
pretrial interview
listening to
of Mr. Winterstern. And during that pretrial interview, it was actually asked by Ms. Morrissey what Mr. Winterstern's role was as
without
a producer.
interruption. I love this judge. I really like
This pretrial interview, Your Honor, that I have was January 8th of 2024. And so January 8th of 2024,
Yeah, she's very chill.
he was
Matrix. I
asked a
agree.
number of
She's
questions
very
about
chill.
his role as a producer by Ms. Morrissey. Ms. Morrissey also asked Mr. Winterstern about other producers' roles. Ms. Morrissey also asked about Alec Baldwin's role as a producer on set. And this is someone who would have personal knowledge of that, unlike any of the other witnesses that the state is calling to try to make out this producer theory. So there is zero prejudice to the state because everything that we would be going into in the trial has already been covered by Ms. Morrissey in their own pretrial interview for a witness whom they called in the previous trial. And so we understand that they're now trying to claim prejudice, but it's because that they know that this sinks their claim and that this is a much more appropriate witness than any of the 3 whom they've listed to try to go after Mr. Baldwin on this producer theory. So we ask, Judge, we are just asking for basic fairness and due process.
Not unreasonable.
There are other avenues. If the court wanted to give them another interview, they could do that. But again, they've already had a substantive interview of him, and we would ask that the court allow Mr. Baldwin to present this defense.
Thank you. Reply?
Yes, Your Honor.
Your Honor, the issue is the court issued a scheduling order in this case, not in the Gutierrez case, in this case. The court set deadlines for pretrial interviews. It set deadline for witness disclosures. And the fact that Mr. Winterstern was interviewed in the Gutierrez trial does not obviate the need to have a pretrial interview of him in this case, because in Gutierrez, he was listed as a witness for the state. In this case,
It's
the
going to get
defense is calling
denied.
him.
She's going to agree with the
The state
prosecution.
has no idea what he is going to be testifying about. The state has not been given any prior statements as it relates to this case. And as the court can see, Your Honor, what we have here is by this email is that the defense was put on notice, and they call it a producer theory. It's really not an independent theory of liability. What this evidence goes to, it goes to Mr. Baldwin's knowledge that his conduct on set was reckless, and it was in essentially wanton disregard for the safety of others. And his role as a producer made him keenly aware of the safety rules that apply on set, what his responsibilities are. And so,
Right.
as we'll argue in the 404 or the intrinsic evidence motion, this particular type of evidence is germane to the defendant's recklessness in order for the state to prove the involuntary manslaughter. They cannot claim that this is a new theory. As I noted, Your Honor, page
a real judge
186 to
finally,
187
Time
of the
Lord.
grand jury
Oh, you're going to
transcript,
love this
which
judge.
is
I've
attached
seen
to
some
the
of the
state's
previous
June
motions
21st,
that she listened to,
2024 response
virtual
to
motions.
the defendant's
She's
motion to
great.
file a supplemental brief. Ms. Morrissey
Yeah, and it's
goes
good
into
for Chandler.
great
She's
detail
learning to
with
want to be
Mr.
a lawyer.
Carpenter, the state's expert, about
Morning fraud at Wrangler.
Mr. Baldwin's role as a producer, his responsibilities as a producer. Mr. Winterstern, from what we understand, has very little producer experience, but nevertheless, we would argue to the court, Your Honor, is what is he going to be testifying to in this case? The state has no idea. That Ms. Morrissey spoke to him in the context of the Gutierrez trial is irrelevant to the court's analysis in this case. Under Lemire and under Sanders, and in Sanders, it's 1994 New Mexico Supreme Court 43 at paragraph 26. The court noted a defendant's right to present evidence on his own behalf is subject to compliance with established rules of procedure and evidence designed to
That was
assure
worth the
both
expire.
fairness and reliability in the ascertainment of guilt or innocence. If the state had done this, you know they'd be up here screaming to the court that we have sandbagged the defense. Your Honor, the state is entitled to a fair trial as well. And so we'd ask that the court exclude Mr. Winterstern. Thank you.
All right, the court makes the following ruling. The court denies the state's motion. With respect to Mr., well, first with respect to both
Yeah,
of
that is
them,
Chandler.
I don't think that you've established prejudice, and to the extent that you want them excluded, certainly there are other remedies. I will have the defense make Mr. Wingerstein available for a pretrial interview. And with respect to Zook, I'm not quite sure now. They're saying they want an interview. All right. Is that a problem for
No,
you?
it's not her because she's not wearing glasses.
Work out the issue.
All right. Thank you. All right. Remember, I believe it's 10 minutes aside, half an hour for lunch. So
Half an hour for lunch.
I'll
That's
start
what we
with-
do for lunch.
move these. All right, state's motion in limine to exclude evidence or separate civil
Okay,
suits
Chandler's in
against
the second
defendant
row.
and/or
So when the
Rust
camera
Productions.
zooms out, we'll be able to see her. Baldwin is not in there. Somebody said Baldwin looks sleepy. Baldwin is not in the courtroom today. He'll be there tomorrow.
And if you're going to do a reply, you're going to need to figure out how you're going to do that. 3 minutes for the reply.
Thank you.
Okay.
I'll be brief. This one's
And
not
I hate to tell you, I'm going to cut you off right away. Okay.
understood. Your Honor, in this particular case, as the court is aware, there have been multiple civil lawsuits filed against Rust Production and against the defendant himself. Mr. Joel Souza, one of the state's witnesses, filed a civil lawsuit that I understand has since been settled. There are three
The
other
civil
states'
case.
witnesses, or four, I believe, other states' witnesses who have pending civil lawsuits. We would respectfully ask that the court preclude the defense from cross-examining first Mr. Souza about his settled civil lawsuit. And there's a case right on point, which I cited in the motion, which is United States versus Whitehead. It's a U.S. 10th Circuit Court of Appeals decision, 562 Federal Appendix at 701, wherein the court affirmed the district court's denial of cross-examination on a civil lawsuit that was related to the criminal case, but that had since been settled before the criminal case went forward. And that's the issue with regard to Mr. Souza. The fact that he had a civil lawsuit and settled it is irrelevant
Is that
and
Baldwin?
should
I
not
can't,
be
I can't
allowed.
recognize him. He's got
With
like
regard to
glasses
the
on,
other
he's shaved.
witnesses, Your Honor, although
I thought he's not
we
supposed to be in
understand
the
and the
courtroom
state
today. Control
acknowledges
motions.
that under state
His
versus
presence is
Santillanes,
waived.
the court noted that the pendency of a civil action by prosecuting witnesses seeking damages is a proper subject of inquiry. But the court also recognized that it's proper if the civil
Okay, if it's
action
Baldwin, then
is
it's
for the
Baldwin.
same offense that is being tried. And that's where the state respectfully submits there is a distinction between the pending civil lawsuits that four of the state's witnesses have versus what the court looked at in Santillanes. My understanding is that the pending civil lawsuits that the four states' witnesses have to do with intentional infliction of emotional distress and negligence as a whole in the filming or during the time that this filming was taking place between October 6th and October 21 of 2021. So it's not specifically related
Okay, I
to
stand
the
corrected.
charge that the
It's Baldwin.
defendant is facing. Now, if someone had a pending wrongful death lawsuit, I would concede that that is germane and is subject to cross-examination. But because there is a difference between the civil lawsuits and this pending criminal prosecution, we would respectfully request that the court deny or preclude the defense from questioning these witnesses about their pending civil lawsuits, unless the court has any questions, Your Honor. Thank you.
You're right. It is Baldwin. Holy crap. He cleaned up real good. That's
Your
why I
Honor,
didn't recognize
the
him.
defense has no present intention of questioning Mr. Souza about his settled lawsuit. I'm not waiving that issue, but I don't think the court needs to get there today. The rest of this issue is quite easy. This cross-examination was done during the Armour's trial, as the court no doubt remembers. In that case, there was zero financial motive. In this case, there is a suits against Mr. Baldwin directly, an extreme financial motive. And number three, the lawsuits are exactly on point. It almost actually looks, if you look at the lawsuits versus the state's case, like they copied and pasted it. And I know this case seems in some ways like a civil negligence case, but it literally looks like they may have copied and pasted part of the lawsuits. So they're directly on point. None of their cases say what they claim. The case law on this is clear. It's actually one of those issues that's universal amongst all 50 states and all courtrooms in this country. You can always cross-examine a witness about their motive and bias. You can always ask them if that's the reason they're testifying in a certain way. And that's what the confrontation clause promises us, and that's what the Constitution demands. I have nothing further.
Any reply?
Just very briefly,
Damn, that was smooth.
Your Honor, it's a fine distinction, and it's made in State versus Santillanes. If the civil action, and I quote, was for the same offense being tried in a criminal action, absolutely agree, it would be subject for cross-examination. But I would respectfully submit that there are differences here between the civil actions and this criminal prosecution. So we'd ask that the court preclude any cross-examination.
All right, the court makes the following ruling. Evidence of pending lawsuits against defendant by testifying prosecution witnesses is proper impeachment evidence. The motion is denied. All right, next up is defendant Alec Baldwin's motion in limine to preclude improper impeachment evidence. Is that what you all have as the next one? Or was that at the end?
is there a number?
Is it
Well,
Baldwin?
that's the problem. In the beginning, you didn't number.
That's my fault. I'll take responsibility for all faults to date.
Okay, so you want to do these at the end, and you want to start with, what do you want to do?
I'm happy to do motion, what looks to me like motion eliminate one from,
Okay,
the-
we'll do
the
these other
defense.
ones later. All right. Defendant Alec Baldwin's motion in limine to preclude improper prosecutorial conduct and require an orderly trial.
Oh, this is going to be a good one. Prosecutorial
and
misconduct.
yes, Your Honor, I think this is a good place to start today, because this is sort of my main issue throughout the day and what I'm going to ask to address at various points. And that's why I'm going to keep my remarks so brief on my motions, because hopefully the court will give me the courtesy of a few more minutes when I need at the end. But essentially, the court has the papers. Their response that the state is allowed to burden shift in certain places, that's their sort of strongest response, misses the mark. I mean, even in the case they cite, right, what the prosecutor does, it's one remark in summation where the prosecutor says, I, of course, have the burden of proof. It never leaves this table. This is a very serious proceeding, and I have the burden of proof. Just so you know, though, you can consider, and then they make one remark. That's the context of any case that goes against these basic propositions that are also the same in every single state in this country. So the reason that I had to make this motion is because in reviewing some of the trial, and I haven't been able to get through every bit of it that I want to on this subject, but it's constant issues with controlling the prosecution from doing things that are just straight and proper. And so I don't know what to do in that circumstance. I've never made a motion like this before, but it's objection. This witness doesn't know that. Objection. They don't know how to identify the picture. We have plenty of other witnesses. Sometimes it was no objection at all. Sometimes the prosecutor just called out from the prosecution table and started saying, I would request the witness read the entire transcript. He can't answer that. And then there's the questions, and we'll get to this in another mill, which is constantly, every single witness, they'd ask a question, what happened next? And where was Miss Hutchins during that? Where was Miss Hutchins? Oh, she was in the helicopter. And then they would go on, and they would ask another question about the chronology. And they say, well, where's Miss Hutchins? She's in the helicopter. And so, this is, it's misconduct. You can't do that. You can't do that as a prosecutor. You're not allowed to do that as a prosecutor. It's very serious to do that as a prosecutor. And so eventually the court at some point stopped Miss Morrissey from doing the coaching, speaking objections. And then Miss Morrissey began, every time her name was mentioned in a question, she began to stand up and say, well, I'm being talked about in this question. And she began interrupting the proceedings. So I didn't know how to address this. I don't know how to address this, even as I stand before Your Honor. But my request would be objection, relevance, objection, hearsay, and nothing else. And in the very rare circumstance when an issue rises to the level of extreme importance or constitutional imprint, a lawyer can approach. If there's something very complicated, a lawyer can approach. But otherwise, none of those tactics and devices should be used at this trial. We've come a long way to get here. The court has been very patient. All that we want is a fair trial. And for the rest of this, I would rely on my papers. Thank you.
Response.
Thank you.
Your Honor, I think we can agree on one thing. Absolutely, without a doubt, and that's beyond dispute, the state has the burden. And the state cannot shift that burden to the defendant. Absolutely agree. However, there are those limited circumstances where the state is given latitude with regard to countering defendant's arguments. For example, the defendant comes in and, as the court has heard, presents argument that somehow somebody modified this firearm. Where is that evidence? The state should be allowed, and it has been allowed, and in fact, in State versus Aguayo, which is cited in the motion, 1992, New Mexico Court of Appeals 124, the courts have allowed the prosecution to argue that the defense didn't present witnesses to support their defense theory, but the state has the burden. There's no question about that. So we would ask that the court give the state some latitude with regard to responding to defendant's arguments. And I can guarantee you, we will not, the state will not, under any circumstances, shift the burden to the defendant, because that's improper and it will not happen. With regard to vouching for opinion or for witnesses, I agree it is improper to vouch for a witness's credibility. But there are circumstances, Your Honor, where the state is permitted to comment on the veracity of a witness as long as it's based on evidence. If the prosecution says, it's my opinion that this witness was truthful, absolutely improper, absolutely agree. But if it's based on evidence that a witness testified to X and there's corroborating evidence of X, the state is allowed and should be allowed to argue to the jury that this witness has testified truthfully based on the evidence. And finally, part of this, during closing argument, Your Honor. Yes, no, not during trial. With regard to coaching witnesses, Your Honor, which is the last part of this motion, I agree as well. A prosecutor must not coach a witness, particularly must not coach a witness to testify falsely or to phrase the witness's testimony. However, it is absolutely proper for the prosecution to meet with witnesses, to prepare to testify. The defense has taken the position, I believe, that any sort of preparation with witnesses is improper. I would ask that the court not allow the defense to try to imply to the jury that meeting with witnesses prior to their testimony is improper. Coaching, absolutely. That the prosecution to tell a witness what to say, absolutely agree. But to meet, to prepare.
By the way, I'm really sorry to pause this for a second, you guys, but we got some breaking news on the Karen Reed case. Alan Jackson filed an affidavit. Apparently, he was contacted by one of the jurors, and this was filed this morning at 9 a.m. And it's now all over the internet. You can check out my Twitter. I just posted about it. Apparently, on the 2nd of July, on Tuesday, Alan Jackson was contacted by a juror A, and Juror A said that she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform Alan Jackson of the true results of their deliberations. Juror A indicated that he or she, they're keeping their identity secret, believes it is important to disclose such results because she believes those results significantly impact Ms. Reed's rights. Juror A told me that the results of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder, and she was emphatic that count 1, second-degree murder, was completely off the table. Completely. All 12 jurors were in agreement she was not guilty of that crime. Juror A also told me that shortly following that determination regarding count 1, the jury also unanimously agreed Karen Reed is not guilty of count 3, leaving the scene of the accident. Oh my God. This is huge. This is huge. And what are we left with? We're left with count 2, right? So on July 1st, I'm going to keep reading. When the jury presented a note to the court, all counsel were ordered to the courtroom. This was the third time that they're like, we can't decide. The note was not presented to counsel for review, which is true. The court indicated that the jury was in an impasse. Once the jury was seated, the court read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, or the prosecution for that matter, the court declared a mistrial and excused the jury. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including the lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Nor did the court on its own inquire of the jury foreperson on which counts the jury was in an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for counts 1 and count 3, and Ms. Reed was denied her right to receive those verdicts in her favor. And he submitted an affidavit stating under penalty of perjury. Holy crap, folks. Anyway, I just wanted to give you this quick update. We'll talk about it maybe during the break or something. Let's get back to the show.
change my mind. I can see what I want to do is I want to start with you all getting the lay of the
This
land.
is insanity.
And I'm going to be in control of the courtroom. So this is what I'm going to do. I'm sorry that you haven't experienced this because it can happen and it does happen. So that's what I'm going to do. If you all seem to be doing well and you get it, and I'm hearing relevance, I agree, then we can perhaps relax the rule. But that's how it's going to start off. Okay?
I need to remember
All
what
right,
count 2 was.
so,
It was probably like involuntary manslaughter or something.
I don't know what
I can't remember. Give me a second.
Basically,
Let me.
didn't
let me-
really rule except that I'm in control of the courtroom. All right, thank you. All right, next up is state's motion in limine 2 to exclude UNM hospital records of Ms. Hutchins' medical treatment.
Your Honor, we have no present intention of admitting this exhibit. I don't think there's any grounds to exclude it based on redactions, but
Oh, the
this
liquor.
case isn't about the medical issues of Ms. Hutchins, and we're going
they
to
were
address these
divided
issues
on
in
the
the
liquor.
All right,
In
so
another bill.
what is the bottom line? You are,
wait.
no objection?
Hold on.
no objection, Your Honor.
No.
All right, no objection. Let me just write this down.
Wait a second. Hold on. What was count?
All right, so the motion is granted. All right, defendant's motion limine number 2 to preclude inadmissible character and prior evidence and statements unrelated to the
Manslaughter while
events of
operating motor
October
vehicle
2021.
under the influence. Oh.
Good morning, Your Honor. It's nice to finally see you in person. Thank you. So I'll be brief. You just heard Ms. Johnson in response to
Is that it?
our
No, I don't
arguments
know.
about the civil suits say
My
the civil
brain is going
cases
miles an hour.
are about October 6th to October
Yes, that's Alec
21st,
Baldwin. It's
the
confirmed
whole
now.
negligence. And that's very different from what Mr. Baldwin has been charged with. He's been charged with what happened on October 21st. And yet, when you look at the 404B disclosures that the state has provided, all of those disclosures relate to events that happened before October 21st. Mr. Baldwin swore on set. He cussed. And therefore, what? He committed homicide? Mr. Baldwin pointed the gun earlier or rushed people earlier. And therefore, on October 21st, he had a propensity to do it again, or he committed homicide. That's exactly the kind of propensity evidence that must be excluded, Your Honor. The state cites 3 cases about this. The first one, all of them illustrate it, but the first one illustrates it best. The US v. Reggio case. They say Reggio was a commercial trucking driver, and the state was allowed to introduce evidence of what he did before the commercial trucking accident that he was involved in. But when you look at the case, what actually happened was Reggio had a medical condition. His doctor diagnosed him with it. He went and he applied for his commercial trucking license, and he denied having the physical condition. He knew that condition made it unsafe for him to drive. He got his license, procured by that lie. He drove, he got in an accident, and someone died. And he was charged with involuntary manslaughter based on an unlawful act that he committed before. What was that unlawful act? He was driving knowing that he wasn't physically qualified. That was the predicate act. So the state said, we're going to admit evidence of that predicate act. He lied to get his commercial trucking license. And that's going to show, A, the predicate act. It's also going to show he knew it was dangerous for him to drive. And they were going to bring the doctor in there to say so. That's not at all what's happening here. Mr. Baldwin swearing on October 16th is not a predicate act. It's not a crime at all. Whether he checked the gun or not on October 16th, not a predicate act. And so the cases that they cite, starting with Reggio, have nothing to do with how they're trying to use the evidence here. Now, it might be different if they said, look at Mr. Baldwin on October 16th. Look what happened. He was rushing people. He was pointing the gun. He was doing all these crazy things on set. And look what happened. There was an accident. Someone got hurt on the 16th. And he knew it was dangerous to do what he was doing, yet he continued to act on the 21st in the same way, knowing that harm happened before. That might be relevant, but that's not what happened here. No one was injured because he swore at someone on the 16th or threw a gun on the ground on the 16th. They're trying to use it to show propensity. Reckless before, reckless now. They cite two other cases, the Coughlin Lambert cases. Coughlin, they say, the court allowed the government to introduce evidence of his prior athletic activities when he had submitted a victim's compensation claim after being injured at 9/11. The state says, see, look, prior activities, case now about a fraudulent claim, 9/11. But the fraudulent claim charge against him was that he wasn't actually injured at 9/11 as severely as he said he was. Because look at, he's running around, he's an athlete. He's clearly not injured. So it had nothing to do with propensity, had nothing to do with he's a bad guy and therefore he committed fraud on the victim's compensation fund. It was directly relevant to it. Same with the Lambert case. It's a bank robbery case. The defendant was talking about robbing a bank before, planning the locations, plotting it out. And then lo and behold, not so long after, he robs a bank. He says, you can't do that. You can't admit character evidence. The court says, no, you were talking about robbing a bank. You were planning the location. That is directly linked to the fact that you did, according to the state. So all of the cases they cite have a very direct link. The evidence that they're trying to admit against Mr. Baldwin, it's all propensity. Mr. Baldwin's not a murderer on the 21st because he swore on the 16th. They're going to try to show that. That's highly improper. It should be excluded. Thank you, Your Honor.
May I please the court? Your Honor, first, these other acts evidence constitute res justi. This is intrinsic evidence. And I can tell you, I'm intimately familiar with the United States versus Riego case because that was my case. Mr. Riego was charged with 4 counts of involuntary manslaughter. And the court allowed the introduction of his prior medical records from about 2 years before the incident happened. So the traffic accident happened on September 7th, 2019. And Mr. Riego was driving on the interstate on a phone call with his wife. And then he unfortunately crashed into the victims and killed 4 people. The court allowed evidence of those medical records and allowed evidence of his application to get his commercial driver's license, where he indicated that there were no medical issues. And also the court noted in allowing this as res justi or intrinsic evidence, that this evidence goes to the defendant's reckless state of mind. So for involuntary manslaughter under the state statute, as the court knows, the state has to prove that the defendant acted without due caution and circumspection. And so we have to prove criminal negligence, that the defendant willfully disregarded the rights and safety of others. And the uniform jury instruction, and it's cited in the Henley opinion, that the defendant should have known of the danger involved in his or her actions and continued to act. So intrinsic evidence is evidence that is directly connected or provides context to the jury of the charged offense. And it's connected to the factual circumstances. So what the defense wants is for the jury to be, for the state to only be allowed to introduce in a vacuum the moments leading up to October 21st, 2021, when the defendant shot Ms. Hutchins. However, intrinsic evidence allows the introduction of evidence that's inextricably intertwined with the acts that form the charged offense. So I would respectfully submit, Your Honor, that this is the state has submitted this notice on June 17th as required, putting the defense on notice that these different videos show the defendant acting in a wanton and reckless manner. For example, there are 8 videos, and those are exhibits 61, 62, 63, 67, 68, 72, 74 and 76, where his finger is on the trigger when it shouldn't be. There are some videos, 7 videos that show the defendant sort of horse playing around with guns, exhibits 95, 111 to 115, and 65. Evidence of the defendant using the gun as a pointer, exhibits 91 and 58. These are inextricably intertwined with what he did on October 21st, when he pointed that gun at Ms. Hutchins, cocked the hammer, and pulled the trigger. And so that prior evidence, those other acts evidence, basically put into context what happened on October 21st and established the recklessness mens rea. In the alternative, oh, and there's another issue, Your Honor. So the defense are going to be arguing to the jury, and we've seen the preview, that this gun was modified and that it didn't work. Again, as intrinsic evidence, these videos show on a number of occasions that this gun was working perfectly fine. It had no malfunctions. Every time the defendant fired it, he pulled the trigger. There were no issues. So it is actually relevant to demonstrate that there were no issues with this gun. In the alternative, Your Honor, these other act evidence instances of the defendant's conduct are admissible under Rule 404B to show knowledge and to show lack of mistake. Knowledge in that the defendant should have known on October 21st, when he was pointing that gun at Ms. Hutchins, that his conduct was wanton and reckless. And we prove that by the evidence of the other instances where he acted in a wanton and reckless manner as it relates to this gun. And it also shows that there's no mistake. The defense is going to argue, oh, this gun just discharged on its own. I didn't do anything. This is not a mistake. Each time he had his finger on the trigger, previous occasions when he shouldn't have. And so I would respectfully submit that they are admissible as intrinsic, or in the alternative under 404B. Thank you.
Any reply?
Yes, Your Honor. 2 points, Your Honor. Number one, the state told you what it's going to do. It's going to try to show recklessness before and therefore recklessness on October 21st. That's propensity evidence. That is not what Reggio allows, not what Coughlin allows, not what Lambert allows. They cannot do that by showing what happened before is an indication of what happened after. There was no, as I said, aha moment connecting state of mind before to state of mind on the 21st. No accident happened. Reggio, the reason state of mind was inextricably linked was because he lied about his medical condition, knowing he couldn't drive. That's the proof. That was inextricable. It was a predicate act. None of these are. On top of that, most of the clips don't show Mr. Baldwin shooting. They show him swearing or putting a gun on the ground or taking a gun when he's lying on the ground and sort of accidentally pointing it. These issues are not what they're trying to show about the 21st. He's not shooting, showing a malfunctioning gun in most of them. They're trying to bring it all in, not to show what happened on the 21st, but to use it as reckless evidence of before and therefore after. She just told you that, Your Honor. I have nothing further.
All right, thank you. You're going to see me looking at my laptop.
I like how short and sweet the arguments
took
are for the
notes
defense.
on these.
They're feeling strong about it.
matters on my laptop. All right, the court rules and reasons. Evidence regarding defendant's handling or firing of the firearm or firearms firing during the filming of Rust are relevant in that they have any tendency to make a fact more probable, to wit that the firearm worked properly during the filming and that defendant Baldwin was not handling the firearm safely. This goes to facts of consequence in this action. Applying the balancing test in which the court may exclude such relevant evidence if probative value is substantially outweighed by unfair prejudice, confusing the issues, etc. The court balancing test does not weigh in favor of defendant. However, any of the videos or any evidence or pictures which relate to Mr. Baldwin not handling or that goes to the defendant's the gun didn't work, and they're showing that it did work because he's shooting videos that show that he's cocking the gun when he doesn't need to cock the gun, goes to the negligent use of a deadly weapon. However, everything else regarding him yelling at the crew or telling people to hurry up. None of that is relevant, and that is propensity evidence. So I think that you all can look at the videos, look at the any of those exhibits, and agree which ones meet my ruling. And if you can't do that, then I'll have to help you out. Okay? So denied and granted in part. All right, state's motion in limine to exclude irrelevant evidence and witnesses. Let me know if you all need a bathroom break or anything. Otherwise, we're going to noon. Now you need a bathroom break.
This is state's motion in limine 3, correct?
Yes, it is.
Okay. Your Honor, we filed this motion because we understand that the defense plans to call Robert Schilling. Mr. Schilling was a private investigator that was hired, who was hired by the prior prosecution team. When Ms. Morrissey took over the case, Ms. Morrissey terminated Mr. Schilling because he had done absolutely nothing on the case, essentially. So in response, Mr. Schilling sent an email to Ms. Morrissey and copied Mr. Bowles as well, and essentially criticized the law enforcement investigation and essentially said, I can't undo this disaster of whatever, I'm paraphrasing, of this investigation. So it was essentially a strong critique of the law enforcement investigation. I would respectfully submit that under United States versus McVeigh at 153 F 3rd 1166, page 1192, this type of evidence is inadmissible. Now, if there was, for example, evidence of what happened to the gun is going to be admitted. That's, the state does not dispute that or disagree with that. But just to bring in a witness to critique and criticize the law enforcement investigation is improper. And it's the type of evidence that McVeigh, the 10th Circuit Court of Appeals in McVeigh, noted would be improper. So we would ask that the court exclude Mr. Schilling from testifying, because the entire purpose is to bring him in to talk about how disappointed and disgruntled he was in terms of the investigation, but there's a motive there. He was terminated and he did nothing in the investigation. We're also asking the court exclude Sheriff Adan Mendoza from testifying. I believe the defense in one of its responses indicated that they don't plan to call Sheriff Mendoza, but in the event that they do, we'd ask that the court exclude him as irrelevant. There is nothing that Sheriff Mendoza did with regard to this substantively, with regard to this investigation. He oversaw his deputies who were conducting the investigation, but he wasn't involved. And so to bring him in again, it's just to set him up there to criticize the quality of the investigation. And we'd ask that his testimony be excluded as irrelevant. And I believe all he did was do some press conferences too. So I don't know if they're planning to inject that in front of the jury. And I would argue that that's irrelevant. And even if the court believes it's somehow relevant, it should be excluded under Rule 403.
Oh my God. The jurors have a group text going and they're going back and forth deciding what they're going to do. I'm sorry. I'm reading like Karen Reed stuff right now. Oh my God. The jurors have a group text going and they're deciding what they're going to do, if they're going to come forward or not. Are you kidding me? They're saying there was no consideration for murder 2. Manslaughter started polling at 6-6 and then ended deadlocked at 4 not guilty, 8 yes guilty. This is according to Yannetti, according to another juror informant. They were very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately voted no. The cause of death was twofold of hypothermia and head injury. of which the juror was convinced that the vehicle did not cause both. The whole jury felt very intimidated by Higgins' presence at the end. What? They were intimidated by Higgins? They were not sure what they were going to do. They're going to lay low for a couple of days and see where it takes this juror. They haven't ruled anything. They haven't ruled out anything yet. The jurors all have a group text going. Oh my God. Oh God.
Motion hearings, Mr. Bash argued that, or it was argued actually to Judge Ellington before the grand jury, that the only way that the state could prove this case is if they prove that the defendant knew that there was a live round in this firearm. That's improper argument of the law. That's not what the law is. And so, and I guess this is an issue that the court will have to take up as we proceed during trial, but just wanted to alert the court because there's been some argument in the past that the defense is trying to rewrite the law in this case, and that's improper. Unless the court has any questions, Sharon. Thank you.
Oh, wait a second. I'm sorry, not Higgins. They meant they were intimidated that Brian Albert was in the room.
Quickly, each of the issues, because some of them are
Oh
premature.
my
and we
God.
can push them off and probably won't raise
Sorry.
issues. But to start with,
Not Higgins. They were intimidated that Brian Albert was in the room right before they went to deliberate during closing arguments. Oh. Wow.
you put the gloves on? Why'd you turn the lapel video off then? Why didn't you turn it on? These are all issues that are central to cross-examination in a case to challenge bias, improper motive, or incompetence. We've cited dozens of cases to you, Your Honor, cases where this wasn't admitted and it was reversible error. Schilling is part of the investigation. He's relevant to bias, motivation, and competence. He should not be excluded, number one. With respect to Sheriff Mendoza, we don't presently intend to call him. It's premature, I think, to exclude him. To the extent we want to call him, circumstances come up where it's appropriate. We'll raise that with you, Your Honor, in advance. But as of right now, we don't presently intend to. So I'd ask that you hold off on ruling because it's premature. With respect to biographical information, we don't intend to present biographical information, Your Honor. Don't think that's an issue. With respect to the evidence of what Mr. Baldwin's subjective knowledge was, we don't intend to argue that we are the givers of the law. Your Honor will, of course, instruct the jury as to what the law is. We do intend to argue that Mr. Baldwin didn't have subjective knowledge of a substantial risk to Ms. Hutchins' life because there wasn't a live bullet. In his mind, he didn't think there was a live bullet in the gun. You'll instruct the jury what they do with that. But that's certainly something we should be able to argue as to his state of mind. We won't tell the jury instructions. We won't tell them what to do. You will, of course, do that, Your Honor. And so you should deny the motion with respect to that issue. Yeah, we don't intend to raise that either, Your Honor.
Thank you.
And again, if it comes up where there's a circumstance where it's appropriate, we don't foresee that at all, Your Honor, then we'll raise that with you, but we certainly don't intend to raise that.
And get garnering sympathy.
Same thing, Your Honor. We don't intend to raise those issues.
Okay, thank you.
You're
Oh, sorry,
All
I
right.
forgot to.
The court rules and reasons as follows. The court finds that Robert Schilling's testimony regarding the Santa Fe County Sheriff's Office investigation as to what he saw and learned during the investigation is relevant. The state will present evidence of its investigation and how Mr. Baldwin came to be charged as a defendant for involuntary manslaughter. Mr. Schilling's testimony addresses that part of the state's presentation of evidence at the trial, and the investigation is of consequence in determining the charges against Mr. Baldwin. The probative value of his testimony is not substantially outweighed by a danger of unfair prejudice. I will reserve on Sheriff Mendoza. Nole Prosecchi is stipulated to that it will be not introduced. The garnering sympathy is stipulated to that it will not be introduced. And I'm not going to, certainly, you all can describe an opening statement, what you think the facts are intended to show. And I think that you can describe what Mr. Baldwin's state of mind was without going into the elements. Okay? So it's granted and denied in part. All right, next up. This is state's motion limiting number 3. Defendant Alec Baldwin's motion in limine to preclude argument, testimony, and evidence relating to Baldwin's role as a producer.
Is the defense motion?
Yes.
Okay, sorry.
Did we? Yeah, I just did yours. Now it's theirs.
Your Honor, the state intends to introduce evidence of Mr. Baldwin's role as a producer, even though Mr. Baldwin's role as a producer happened leading up to October 21st. As I just said a few minutes ago, Ms. Johnson told you nothing that happened before October 2021 in those civil cases is at issue here. The whole of the negligence, October 6 to October 21, that's the civil cases. That's not why we're here today. But the producer evidence is everything leading up to October 2021, October 6th through the 21st. They're trying to hold Mr. Baldwin responsible for what he did as an actor on the 21st because they claim he was reckless as a producer leading up to that time. That's a theory of vicarious liability in the criminal law that is not recognized. It's also far more prejudicial than it is probative because the jury's going to hear about what a producer does. They're going to hear about the producer being the boss, the buck stops with him, etc. And the risk is that they think Mr. Baldwin's responsible for what he did on the 21st because he's the boss, he's the CEO, he's in charge. But that's not a theory of liability, Your Honor. On top of that, there's no evidence at all, you won't hear any, that he hired Hannah Gutierrez-Reed, that he set the schedule, that he set the budget, period, full stop. What else did you hear? The state said Mr. Baldwin's role as a producer shows that he was keenly aware of the safety standards. 2 issues with that, Your Honor. The state has said repeatedly in this case that Mr. Baldwin didn't violate the safety standards under Safety Bulletin number 1. He violated New Mexico law. They said that, page 29 of their opposition to our motion to dismiss the grand jury indictment. The fact that Mr. Baldwin was a producer is entirely irrelevant, highly prejudicial. It should be excluded.
Your Honor, as the court is aware, relevance does not exist in a vacuum. So the evidence that the defendant was a producer is relevant to demonstrate to the jury that as a producer, he is aware of his safety obligations, the safety duties, and there will be evidence of the bulletin number 1, which sets out movie set safety rules and how Mr. Baldwin indeed violated those. I think what Ms. Morrissey indicated in her response is that he did violate New Mexico law. But to demonstrate that the defendant's conduct was reckless on set, the state is also going to introduce evidence that he violated these set safety rules that are in place for actors and producers to follow. The arguments of defense, they go to the weight and not to the admissibility. They can cross-examine the witnesses because many state witnesses are going to testify that the defendant was the boss on set. And Your Honor, with regard to what this is relevant to, it's relevant to his recklessness because we have to establish, again, it's not just in a vacuum, that the defendant's conduct on this set was reckless, and therefore on October 21st, he should have been aware that his conduct of pointing a firearm at another human being, cocking that hammer and pulling that trigger is reckless conduct. And so I think that both sides quoted the producer agreement. There are no limitations to this producer agreement. And it goes to the issue of the defendant's reckless state of mind. And Your Honor, I just wanted to briefly address something that I think was relevant to the,
Tell me what the safety bulletin says that the producer, you're referring to bulletin number 1. What are you relying on?
well, there are a number of requirements as it relates to firearms, that the actor and producers are responsible for the safety of others on set, for the safety of themselves and of others on set, that they are to treat a firearm as though it's always loaded.
Check my
Do not
tweets.
point a firearm at another person. That is also, it's for both, Your Honor. These are set safety rules.
But what about, so you're not even relying on that?
We are, Your Honor.
In your response, you said that you weren't talking about the SAE guidelines, you were talking about New Mexico law.
Well, Your Honor, I think that these are two different issues that are being conflated. So Mr. Baldwin is charged with involuntary manslaughter under New Mexico law. And how do we prove that?
By the way,
We
I'm going to
prove that by demonstrating his
Megan
conduct,
Fox's channel
not just
during the
on
break to
October
talk about the
21st, but in the
Cameron
days
stuff.
leading up, that by violating
Wild,
these
folks.
on-set
This is wild.
movie set rules, that his conduct was reckless. Because it's not recklessness in a vacuum from
You're talking about the gun, okay? So tell me what you think he did wrong as a producer.
So not just about the gun, Your Honor. So there are two, and that's why I wanted to address there. So there are two components here. So we have his conduct as it relates to the gun, but then his conduct as it relates to, for example, rushing the armorer to reload that gun. That goes to demonstrate his recklessness. There's no regard for the safety of other people. When you're rushing the armorer to reload this firearm, mistakes can happen. And so with regard to his producer role, there is evidence that will be presented that Mr. Baldwin, as a producer, should be aware of all of the safety regulations.
So I did have trouble wrapping my head around this, as you can tell, okay?
I understand.
So the jury's going to hear this and they're going to go, well, Mr. Baldwin was the actor that was rushing, but he was also being a producer at the same time.
It goes to, Your Honor, because it goes to the recklessness. So he is a producer, and his contract states he's also the leading actor. So he's got a dual role, and with both roles, he fails in maintaining the safety of other people. See, what the defense is trying to do is just basically pigeonhole Mr. Baldwin as just an actor who relies on everybody else, and he relied on this armorer to not give him a gun with a live bullet. But his role as a producer requires him, there are more duties imposed on him as a producer. And those duties include, and there's expert testimony that will be presented, that his duties as a producer, well, I understand, Your Honor, but if the court allows the expert testimony, the state will present evidence that the defendant had not just his role as an actor, but as a producer, it's heightened in the sense that he is supposed to be aware of the regulations, of the safety, and that's the most important thing.
I'm just having trouble with this. Okay, I don't understand how you're going to say as a producer, he shouldn't have, as an actor and a producer, he shouldn't have rushed, he shouldn't have said, quick, move.
Well, but so as an actor, of course, he shouldn't have done that, but also as a producer, Your Honor, he is the boss. And as the boss, he is responsible for the safety of other people. So it goes to his state of mind, his willfulness, that he essentially, as the boss, failed the people who worked around him. And it gives him the power to control the safety. So as the producer, he has the power to control safety on set. And there was a tremendous lack of safety on this set. And so as the boss, he's emboldened to do whatever he wants to do. So this goes to the willfulness that the state has to prove.
Producer to do whatever he wants to do.
Because you're going to hear testimony from witnesses, if the court allows this, who will say he was the boss, he was calling the shots, he would rush people because without regard.
Maybe that's his personality as an actor.
Well, but that's irrelevant, Your Honor. With regard to his role as a producer, he has responsibilities, and he has a responsibility to maintain the safety of the set. Whereas an actor, perhaps those may be lessened, but as a producer, those are heightened. And so it's relevant to demonstrate his willfulness, the willfulness of his conduct, that on October 21st, he once again disregarded the safety of Ms. Hutchins and Mr. Souza and pointed that gun directly at Ms. Hutchins. And so that is why this is relevant. We can't look at this in a vacuum. And in fact, the court in State versus Duncan noted that relevance does not exist in a vacuum. Instead, it's the logical relationship between evidence and a proposition and issue that the party seeks to prove. We have to prove willfulness. We have to prove recklessness. So in order to do that, the fact that he was a producer and the boss is absolutely relevant.
Let me ask you something. So in the involuntary manslaughter, with respect to the first negligent use of a deadly weapon, okay, that's not the producer, that's the actor.
That is the actor, but he's also charged in the alternative.
The alternative, that he failed to check the gun.
It's more than that.
Well, that is what was given to the grand jury, that he failed to check the gun and pointed a loaded gun at a person. That's what it was in the grand jury. So you want the producer you want to introduce that he was the producer and what he was required to do to be able to prove that alternative theory that he was supposed to check the gun.
Well, and that he wasn't supposed to point it at another human being and to pull the trigger. And so, and as a producer,
how does his role as producer, as a producer, he wasn't supposed to do that?
well, his role as a producer goes to what he is required to know when it comes to safety of others. He has a responsibility to ensure the safety of other people. So it goes to the issue of his willfulness, that on October 21st, when he points that gun at Ms. Hutchins, he should know that as a producer, he's responsible for her safety, because that is one of the things that producers are responsible for, safety on set. And so the fact that there was a lack of safety on this set, Mr. Baldwin should have known that by his action of what he did moments leading up to the shooting of Ms. Hutchins, essentially show a willful disregard for his safety and recklessness.
I tend to
So
agree, unfortunately.
it's not a theory of prosecution. It is evidence that goes to prove an element of the offense. And we would respectfully ask that the court allow the introduction of the fact that he was a producer, and that as a producer, he has obligations to ensure the
Yeah, I
safety
tend
of
to
others.
agree.
And who's going to be your expert witness on that?
May I have a moment, Your Honor, to confirm? So we
Oh,
have
by the
two
way, there's
witnesses, Mr.
Chandler.
Carpenter, who
We just
testified
saw her
before
for a
the grand
second.
jury.
She's
In
right
fact,
over
he
here.
Testified about the producer role. And then Kent Jorgensen, who is one of the individuals involved in drafting and updating the safety bulletins for onset
You
safety.
know that Brian Carpenter was not an expert admitted as a producer in Hannah Gutierrez. He was a firearm expert, and he has not been admitted as an expert because there was no judge to get him to be an expert at the grand jury. So he has not, at this point, been admitted as an expert as a producer.
Right, and we would tender him. Obviously, the court will have to do its gatekeeping duty and role. Mr. Jorgensen, however, and in fact, I think there's a motion pending about Mr. Jorgensen, but Mr. Jorgensen is also an expert on this. He's familiar with what the safety guidelines require of producers and of actors. And so these are germane issues that the state is required to prove, and we'd ask that the court allow the state to introduce this evidence.
Thank you.
Your Honor, I hardly know where to begin, because I honestly don't understand the theory or the facts that they intend to articulate to demonstrate that on October 21st, Alec Baldwin, the actor, committed involuntary manslaughter. They said, well, the safety bulletins explain that. Two things. Number one, they already said in their response that the safety bulletins weren't violated. New Mexico law was. Number two, look at those safety bulletins carefully. I'm sure your honors read them many times. They say nothing about the producer not pointing the gun. They say the exclusive responsibility of gun safety is on the prop master, the armorer, the first assistant director. Doesn't say anything about a producer. There are a number of actors doing the same exact thing that was required by the safety guidelines. Those are SAG guidelines for actors, armorers, the first assistant director, and the prop master. They say, well, maybe it's because Mr. Baldwin was rushing before October 21st, and there, as a producer, I'm not sure what that distinction is, producer, actor, and therefore on the 21st he was. But you just excluded the evidence of him rushing because that's propensity evidence. That's inappropriate. The fact that we're so confused about what the theory actually is goes directly to the prejudice that will far outweigh the probative nature of this testimony. And we'll get into Mr. Jorgensen and Mr. Carpenter later, unless your honor wants to hear about why they are not qualified to testify as experts on producers. I'm sure we can push that on. But the reality is this will confuse the jury. This will be highly prejudicial. They want to show that he's the boss, and therefore on October 21st, as an actor, he committed involuntary manslaughter. That is highly prejudicial, inappropriate evidence, should be excluded.
All right, so what I think is more appropriate is I'm going to revisit this, make my ruling, no more argument on it. But I think that we should do well, you didn't raise Mr. Carpenter except duplicative testimony. And
No, that's just the cumulative expert test motion, Your Honor. That's correct. We raised Jorgensen.
right,
If you want to do Jorgensen now, I'm happy to come back up and talk about Jorgensen.
all right, let's do Jorgensen.
You know, the state intends to offer Mr. Jorgensen on two issues. One is the role of a producer in managing the safety of the set. And the second is the safety bulletins that govern actors on movie sets. Mr. Jorgensen should be excluded. First things first, on the evidence of producer, his opinions on producer. Mr. Jorgensen has never been a producer in his life. He was a camera grip back 25, 30 years ago.
Really?
Never been a producer. We asked him, what is the basis for your testimony as to what producers do, know, what their obligations are on a movie set? He said, well, it's because I get to sit at the kids' table, these are his words, and listen to the adults talking. Your Honor, this is not the kids' table. This is the adults' table. Mr. Jorgensen has absolutely no expertise, and sitting at the kids' table doesn't allow him to sit over there and give testimony about what it is a producer is required to do on a movie set in a criminal trial on involuntary manslaughter, number one. With respect to the safety standards, Mr. Jorgensen didn't draft the safety standards. He's not a gun expert. He was a camera grip, sets up camera angles and scaffolding, etc. He is not a gun expert. He's not an armorer. He's never been a prop master. He's never been a first assistant director with the safety obligations. His role, as he described it, is administrative. They want to draft safety guidelines. Mr. Jorgensen says, I'm going to go find gun experts. I'm going to delegate the drafting of safety bulletins to gun experts. They're going to draft it, not Jorgensen. The gun experts are. And then the gun experts are going to send it back, and Jorgensen wordsmiths and edits. But it's the gun experts who determine gun safety standards on movie sets, not Mr. Jorgensen. He has no basis to offer an expert opinion about gun safety standards, what the standards mean, how they're supposed to apply, because he didn't draft them. He's not the expert. He doesn't know anything about them other than how they got drafted. But how they got drafted is not an issue in this case. His evidence, his opinions should be excluded.
Your Honor, Mr. Jorgensen teaches producers about their responsibilities with regard to set safety. He's going to take the witness stand. He can outline his experience, the position that he holds that allows him, that puts him in the position where he teaches producers about set safety. So I want to be clear. I am not calling Mr. Jorgensen so that he can come and just generally talk about this is what a producer does. I am calling Mr. Jorgensen to come in and talk about the producer's responsibility with regard to set safety. And Mr. Jorgensen is acutely familiar with this because he actually teaches producers what their responsibilities are and how they can have a safe set and avoid getting sued for killing someone. So we've got that as the first issue. Mr. Jorgensen is indeed one of the people who drafts the safety bulletins. I'm not sure where the confusion came in. Mr. Jorgensen is the chairman of the, it's on the tip of my tongue, the industry-wide labor relations. It's on my computer, my apologies. So in that role, what Mr. Jorgensen does is, here's how it works. Representatives from all of the different film unions come together. So we've got somebody from the Directors Guild and somebody from the Producers Guild and somebody from IATSE, and that's who Mr. Jorgensen is. They all get together and they agree and draft these safety bulletins. Mr. Jorgensen is one of those people who sits at the table who drafts these safety bulletins. So his testimony is entirely relevant, one, because he actually drafts the rules that Mr. Baldwin is required to follow, whether we're talking about him as a producer or an actor or anything. And number two, Mr. Jorgensen sits with people from the Producers Guild of America to sit and discuss these safety bulletins and whose responsibility is what, in addition to teaching producers how to do this. So I think that his testimony is absolutely relevant with regard to
argument, but I don't.
These are the safety bulletins. He lays a foundation for the safety bulletins. These are how the safety bulletins are created. This is a safety bulletin. This safety bulletin says, don't point a gun at anyone. Keep your finger off the trigger. Assume that anything that you point the gun at will be destroyed. Those are the safety bulletins that Mr. Jorgensen participates in developing. So his testimony is wholly relevant. Now, whether or not the court decides that Mr. Jorgensen's testimony with regard to a producer's responsibility as it goes to set safety is something that I think the court has indicated that you may want to reserve ruling on until you see and experience how the trial is unfolding. But there's no question that Mr. Jorgensen gets to come in and testify about the safety bulletins that he himself participates in drafting. Thank you.
Just a few
There's
points, Your
Chandler.
Honor. The fact that Mr. Jorgensen is allowed to teach at some university about how people shouldn't get sued in civil cases, it doesn't make him an expert in this court. He's never been a producer.
I think he should
He's not
be
an expert in
excluded.
being a producer. The kids' table doesn't allow him to sit at the adults' table, period, full stop. He also is not a gun expert. Didn't draft it. They're going to have Mr. Carpenter come and testify about safety standards with respect to using the weapon, pointing it, not pointing it. Now they want a cumulative expert, Mr. Jorgensen, who doesn't actually develop the guidelines. He's not the gun expert. He admitted that. He doesn't develop the standards. He said, I hire gun experts to draft those standards. They're going to have two experts, one of whom clearly not qualified on gun safety, Mr. Jorgensen, testify, and then put Carpenter in too. This is a afternoon, a day of testimony of cross. We already have a short schedule, Your Honor. You should limit this testimony. He's not qualified to give opinions on these issues.
I agree. I tend to agree.
The court makes the following ruling. The court will accept Mr. Kent Jorgensen to be able to testify before the jury as to what the guidelines say, but he has no qualifications to opine on what a producer
Yes, I
does.
agree.
He
Wow, this shit's
he doesn't know
really
how
good.
a producer implements those guidelines.
Yeah, he
So,
can talk about the guidelines, but he can't say how they
and
apply.
So he can say these are the guidelines, but
All
he
I can
needs
do
to be
is
a
read.
producer to say, this, as a producer, this is how I thought, this is how I meet
Exactly.
these
He's a freaking
requirements.
light grip.
The other thing noteworthy about Mr. Jorgensen is that based upon his pretrial interview, which is what would have been the time to let the state know, or I mean the defendant know what he was going to testify about, he was all over the place. And basically, he was like, well, I relied on Ross. I didn't talk to anybody. So yes, he will have hypotheticals about, and he may maybe sit over there in the gallery while he's and listen so that he can opine. But I think that interview indicated on top of it that my finding that he's not qualified to know what a producer does. So he can testify about the SAG guidelines, but he cannot opine on whether what Mr. Baldwin did as a producer
Which what are you
was
talking about, Gilliam?
good or bad.
I used to think differently, seemed to think differently earlier.
All right. I'm going to revisit the producer. I'm going to make the following finding.
He's a light grip.
I'm having real difficulty with
He's going to rule against the state. That's literally
the state's position that they want to show that as a producer, he didn't follow guidelines, and therefore, as an actor, Mr. Baldwin did all these things wrong, resulting in the death of Helena Hutchins, because as a producer, he allowed this all to happen. I think that when you look at the relevancy, I think that one of the reasons why I think I'm having a hard time wrapping my hand around it, to be able to say, Mr. Baldwin, because he was a producer and he was the boss, although there are more than one producer, and he couldn't do anything without, looking at those contracts, he couldn't do a thing without running it by, including hiring somebody, without running it by whatever that entity is in the contract. But I do not believe that it has any tendency to make more probable than it would be without the fact that Mr. Baldwin individually as an actor committed involuntary manslaughter through negligent use of a deadly weapon and the alternative theory. The probative value is not substantially outweighed by unfair prejudice and certainly confusion of issues to the jury. So I'm denying evidence of his status as a producer. All right, shall we continue? All right, so we're going to the states now. That was Mr. Baldwin's motion. We have Jorgensen, we finished.
By the way, TMZ has an article
All right.
on Karen Reed. Oh my God.
Defendant out. Oh. State's motion eliminating number 6 to preclude accusations of prosecutorial misconduct.
Your Honor, unfortunately in this case, or this case has been fraught with numerous accusations of prosecutorial misconduct. And they were raised in the context of motions to dismiss for constitutional violations. They were raised in the context of motions to dismiss the grand jury indictment. The court has ruled on those. Those allegations were perhaps relevant to those legal motions, but they're not relevant to what the jury is required to find. So I would respectfully submit, Your Honor, that the court preclude the defense from making arguments to the jury about prosecution. And that would be the main issue I would submit to the court, that the defense would be introducing this. And I noted on page 4 of the motion the allegations, for example, that obviously the jury's going to hear about the accidental discharge test that resulted in the damage to 2 internal components of that firearm. But to argue to the jury that that resulted in a constitutional violation to the defendant's rights is improper. The court has ruled on that motion. There have been numerous allegations of discovery violations and disclosures, and that they were designed to prevent the defendant from receiving a fair trial. Again, Those are legal issues that the court is going to be deciding and has decided and have no place before the jury. That the prosecution conspired with law enforcement to intentionally damage this firearm. Again, that went to the Trombetta motion that the court has already ruled on. There's another issue that there was a meeting you heard about in the motion hearing that Mr. Haig, Lucian Haig, had a virtual meeting with Mr. Ziegler from the FBI where counsel were present. And during that meeting, he asked Mr. Ziegler how he conducted the accidental discharge test. Now, while that is a proper area of inquiry for cross-examination, any implication that that was improper or unethical should be precluded, because under Rule 703, experts can confer with other experts in forming their final opinion. And there's nothing wrong with that. And so I had to bring this motion to the court, Your Honor, because I am concerned that there will be, throughout this trial, numerous allegations that the state has engaged in misconduct and trying to deprive the defendant of his right to a fair trial, and those have no place before the jury, and we'd ask that the court preclude that.
Let me just be clear about what we intend to do and what we don't intend to do. This is not going to be a trial about the ethics of the prosecutors.
Okay.
It's not going to be a trial about they should have dismissed the case a long time ago. They did. They took it back. Well, none of that's coming into this trial. No intention. What we intend to do is exactly what I discussed we were going to do with Schilling, for example. We're allowed to demonstrate that bias, improper motive, incompetence of the government investigation. We're allowed to attack the credibility of witnesses as it relates to the government investigation. For example, Your Honor already ruled that with respect to that meeting between Mr. Ziegler and Mr. Haig, that gets to be disclosed to the jury. In fact, the prosecutors are required to disclose it to the jury, you ruled. And so all of that goes back to the black letter law that we started with on that prior motion in limine. We're allowed to demonstrate the bias, the incompetence, the improper motivations. We're allowed to attack credibility. We're allowed to attack the fact that the FBI destroyed this gun, et cetera, et cetera, et cetera. All of those issues are fair game Hornbook law. We intend to introduce that. The state shouldn't be allowed to preclude it. I have nothing further, Your Honor. It's black letter law.
Thank you. Any reply?
Just briefly, Your Honor, I think we may be in agreement. What the reason for this motion was essentially to preclude the defense from essentially making personal attacks and allegations of prosecutorial misconduct. We agree, and we will present evidence about the Ziegler-Haig virtual meeting about the gun. So, but we just ask, given the contentious nature of this case so far, that we focus on the evidence and not on allegations, personal allegations and attacks during this trial.
All right, thank you. The court rules and reasons. The court agrees that the prosecutor's misconduct as alleged by the defendant in his pretrial motions may not be brought out at trial. The misconduct is not relevant evidence, and even if it were, its probative value is substantially outweighed by the danger of unfair prejudice and confusing the issues. However, to the extent that the defense may elicit evidence about the Santa Fe County's investigation, the FBI testing, the Haig's 3 reports, and his meeting with Ziegler, this evidence is relevant as it makes a fact more or less probable, and the fact is of consequence in the action. And weighing it, the probative value of the evidence is substantially outweighed by danger of unfair prejudice, etc. All right. Thank you. Now we're going to, let me just back up and do these 2 that. State's motion in limine number 4. Let me just make sure I haven't missed one. Okay. State's motion in limine number 4, which is no reference to the potential punishment in the case.
There's no issue.
All right. So that's agreed, stipulated. State's motion limiting number 5 to prohibit the defense from arguing to the jury examples of the definition of reasonable doubt.
No present
Oh,
intention to
so they're
do
like
so.
Kentucky, no definition of reasonable doubt.
We'll
will be
discuss
presented.
reasonable doubt, but those random hypotheticals, I don't think the court should preclude the defense from arguing anything that they choose to, what you decide the law as long as it's relevant, but we have no present intention.
You're not going to give them an example of reasonable doubt. Okay.
Yeah, I have no present intention to do that.
Okay. And that doesn't come up, and that doesn't come up in voir dire either. Okay. All right, where are we? We've got defendant's motion limiting number 4 to preclude improper expert testimony from lay witnesses.
Thank you, Your Honor. The state wants to admit evidence from the camera grip, for example, about how dummies are made, safety standards for armors on set, safety standards for producers, etc. The camera grip. It wants to have the medic testify about the standards for armorers on set.
There she is.
This is improper
Chandler's in
opinion
the
testimony
courtroom.
that can only be given by an expert, not by a lay witness. The state cites the State versus Vargas case, Your Honor. They say it's a two-part test. Part number 1 is, can the lay witness testify about it based on personal observation? Part number 2, can the lay witness rationally connect their personal observation to the opinion testimony? They say they can, because the medic has been on movie sets, it's personal observation. What the state overlooks is that before Vargas states that two-part test, it actually addresses a third one. That's the third prong of Rule 701, which says a lay witness cannot give testimony if it's within scientific, technical, or specialized knowledge. So Vargas says, testifying about movie standards, safety standards, armor standards, how dummies are made, the things that the camera grip and the medic, they want them to testify about, are within the specialized knowledge of someone on a movie set. As Vargas put it, it has to be only within the common experience and knowledge of a lay person. Now, how do we know that that testimony is not within the common experience and knowledge of
What
a
did
lay
you just
person?
call Megan
Because
Fox?
the
A
state
more
says so
attractive
in its
Ally
other
McBeal?
motions. And I brought my notes up here so I can get the language exactly right. In one of its in limine motions, with
I'm
respect
gonna
to
push everything
cumulative
there one-
expert testimony, that's motion in limine number 8.
One-
Here's what the state says. Many people, like many jurors, are not at all familiar with safety protocols on movie sets. And many of the state's experts are being called to educate the jury with regard to safe practices in movie sets. On the Jorgensen motion that we just went over, Your Honor, let me read from that one too. Safety bulletins and protocols on the use and handling of firearms on a movie set, as well as movie production requirements to ensure a safe working environment, are not within the average layperson's knowledge. They try to admit Mr. Carpenter's testimony on that too. They say this is specialized knowledge, expert testimony. They try to get experts in on it, but then they try to say it's just lay opinion testimony that the medic can offer, the camera grip can offer. They cannot have it both ways, Your Honor. And in fact, Vargas reversed a conviction when the court allowed that evidence. That was a police detective who was allowed to testify about his experience with a stun gun, how it was used, how it was made, etc. And the court allowed that at the trial level. The defendant said that's lay opinion. That's lay opinion testimony. That doesn't satisfy that third prong. It has to be tested under Rule 702. The appellate
Yes,
court said, you're right,
we're gonna
reverse
go on
conviction.
Megan Fox's
That was an
channel to talk
expert
about it in a little bit.
testifying because the average and common experience is not that of a detective. And so it had to go through the gateway of 702. The state has not offered, has not disclosed Ms. Schaefer, Mr. Looper, or any of the other witnesses on this set as expert witnesses. They never made that expert disclosure. And to the extent they did, we would have obviously filed an in limine motion to exclude them as experts. They weren't offered as one, so we filed it this way, as experts, because the medic doesn't have the expertise to testify about armor standards, or the camera grip doesn't have the expertise to testify about movie production requirements. We just went through that with Jorgensen. And so this is lay opinion testimony that violates Rule 701, that has not been offered under 702 or met the guidelines of 702. And therefore, any witness that they want to testify about any issue outside of what they observed on Rust, what they saw in other movie sets, what armors do on other movie sets, what actors do on other movie sets, is improper opinion testimony that should be excluded when it's offered by these lay witnesses. Thank you, Your Honor.
If I were the defense, I'd want this testimony excluded also. And let me tell you why it's relevant. Mr. Baldwin, part of his defense, and he's made these statements repeatedly, is I had no reason to think that Hannah Gutierrez wasn't a good armorer. I had no reason to think there was a problem here. This is what he says. He called Jason Bowles' office himself and said, I never had a problem with your client. I never had a reason to think that she wasn't a stellar professional. Well, Judge, you're actually in a unique position because you sat through the Gutierrez trial and you saw and heard the other people, the other crew members who worked on that set come in and say, we knew immediately this lady wasn't following the proper safety protocols. How do we know that? Because Ross Audiego has worked on 60 to 100 films and TV shows. Same thing with Lane Looper. Same thing with Sherilyn Schaefer. She's the set medic. She's paying attention to what's going on with regard to safety. These are not people who are being called as experts to come in and talk about set safety. These are people who are going to come in and say, we had safety concerns on this movie set because we knew from our experience, and by the way, this gentleman was the most experienced person on set, Mr. Baldwin. So if these other folks who had slightly less experience than him had concerns about whether or not Ms. Gutierrez was doing her job properly, this is the way that the state gets to combat the defense of there was absolutely nothing wrong with her. She was an amazing, stellar professional. This court knows that is absolutely untrue. So it is perfectly appropriate for lay witnesses to come in and say, I've been working on movie sets for the last 15 years or 20 years, or in Mr. Baldwin's case, 40 years. And I know exactly how these safety protocols work. And here's what makes it a little bit unique on a movie set is that the safety protocols that take place between the armorer and the actor and the first assistant director is this thing that happens out in the open where the armorer says to all of the crew members, all of these people who are going to come in and testify, hey, does anybody want to see the rounds? Does anybody want to come and see me load the gun? Because you're the people who are standing potentially in the way. So all of these crew members actually get to participate in the safety check, even though he's a dolly grip, as though there's something wrong with being a dolly grip. Even though someone is a first assistant cameraman or a boom operator, they actually get to participate in that safety check because it is their lives that are at risk. So each and every one of these people should absolutely be able to come in and say, I noticed that Hannah Gutierrez wasn't doing her job because Mr. Baldwin has told everyone Hannah Gutierrez was a stellar professional. We're not asking them for a bunch of technical knowledge. Absolutely, I will tell the court, I am not asking any of these witnesses to come in and talk about the difference between dummy rounds and blank rounds. Absolutely not. These witnesses are coming in to talk about, in part, their safety concerns as it related to Mr. Baldwin's conduct and the conduct of Hannah Gutierrez. And we can't really separate those two out because Mr. Baldwin's defense is she was really good. I would also point the court to, this is Farner versus, I don't know if I'm going to pronounce this correctly, Pakar. This is a federal case, 562 Fed 2nd 518. The admission of the lay witness's opinion that the Pakar suspension system was improperly designed due to its failure to incorporate the safety chains was affirmed by the Court of Appeals. Much like the federal courts have allowed lay opinion testimony based on the witness's particular knowledge gained from their employment experiences, keeping in mind this is their workplace, so too should this court. There's a case right on point. Thank you.
Few issues, Your Honor. I'll talk about the cases first, and we'll go back to what Ms. Morrissey said she's going to try to use these witnesses for, and that's expert testimony. The Farner case, it's a design defect case. Farner was driving a truck. The truck suspension failed. There's an accident. Someone died. His widow, he did, and the person in the passenger seat. His widow sued the company that built the truck. She got a person who had driven, his name was Curtis, driven the same exact truck before. Not the same one in the accident, but the same exact make, model, etc. And he said, I drove that same truck. And you fix that design defect by wrapping these chains around the suspension. It was a design defect case where the question was, is that design defect fixable? This was an expert testimony. This was fact testimony. The same with the other cases, the Kate cites, the Valencia case, the Munoz case. Those are cases where the people worked at the company that was at issue in the fraud. And they were asked about that very company when you worked there at the company. What'd you experience? What'd you see? That's relevant to the fraud. They didn't come in and say, I worked at some totally different company. And my experience at that different company, I'm going to apply it here. That's not at all what happened in that case. This case is Vargas, based on the experience that these witnesses had in other movies. Ms. Morrissey told you they want to say, I've been involved in 40 movies before, and applying my experience there to this one, these are the safety problems I had. Even though there's that's expert testimony, because it falls right under that third prong. And number two, it is testimony that they are not qualified to give. There's nothing wrong with being a camera grip, Your Honor. If there's something wrong with being a camera grip and testifying about the safety bulletins for armors, that's exactly what 701 and 702 say. And Vargas says it's reversible to allow it to happen. I have nothing further, Your Honor. Thank you.
All right, the court makes the following ruling. A lay witness can testify if rationally based on perception, helpful to clarifying an understanding of the witness's testimony or determining a fact and issue, and is not based on scientific, technical, or other specialized knowledge. Particularized knowledge is acceptable here, although I don't find it here on what they intend to do. Lay witness testimony of what they observed on set, providing that it's relevant, as compared to what they saw on other sets, makes a fact more probable than it would be without this evidence, and the fact is of consequence in determining the action. That is criminal negligence. It's they are not going to testify about the safety bulletins. They can only testify about what they observed on set, in this set, and what they observed on other sets, provided that they have a sufficient history to do so. However, again, we're going to have to decide relevance. Okay.
Understood.
All right. Court wants to take a bathroom break.
All right, bathroom break,
At
also
quarter
known
of.
as super chat
Okay.
reading break.
All right. Thank you. We're in recess.
Oy vey. It's going well though. I like this judge. This judge is legit. I didn't know New Mexico was only founded like 100 years ago though. I thought it was a little bit earlier than that, but I guess I could be wrong. 1912, huh? Oh, 112 years ago. Kim T says, this guy needs to be Alan Jackson. Awesome you're there sharing with us. You are welcome, Kim T. Thank you for that. Fodder Wrangler says, can we get Proctor's badge as a trophy for my office wall? For mine? Why do I don't deserve it, man. I didn't do the job. If anybody deserves that badge, it's Alan Jackson for show. Alan Jackson deserves that badge, no question. J. Water Roadless Wolf says, this means Ms. Reed could only be retried on the 3 other counts if the juror counts are true. Murder, homicide, manslaughter, the state could retry those counts. You mean, so flip it on the 1 count. So murder, they said, nope, not guilty. Homicide, manslaughter said nope, not guilty. The only one that in the Karen Reed case that they said they were split. It's either 6-6, 8-4, 9-3. We're getting 3 different accounts. I don't know which one is true or not. Let me find it because I tweeted about it. Manslaughter while operating under the influence of alcohol. I think the jurors had a fundamental belief about what it means to operate a motor vehicle under the influence. And we'll talk about it more with Megan Fox. Wow, my girlfriend's laptop is dying fast. I may have to have a notebook for the trial. Because my the computer won't last. That's really unfortunate. Damn. Okay, it's fine. So yeah, I hope that answers that question. Matrix, thank you for the 1 gifted membership. Shout out if you got a membership from Matrix donation. Mel Serenity, thank you for joining on as a member, as well as Annie Ruler. Thank you for joining on as a member as well. A. Kane says, Larry did say there would be big news today regarding the Karen Reed case on Saturday's live stream. This is huge. Yes, I did. I told you I had a source and my source delivered. So that's all that matters. Hashtag free Karen Reed. Thank you so much, A. Kane, for the reminder. Margarita Santelices, thank you for the 2,500 claps. That's a lot of claps. Which are the next steps concerning those affidavits? So now we got to talk about what are the next steps, right? So what is going to happen next? And I'm wondering if I want to do it on my channel or if I just want to save myself for Megan Fox. Of course, you guys are going to vote. Say it, Larry. Say it, Larry. Say it. Yeah, you can't plug it in the courtroom, unfortunately. There are not enough plugs. I do have a power pack, but not for laptops. Not for laptops. And we're just on a quick bathroom break, so this is not going to be a long break. We're going to be back in the Alec Baldwin case in just a minute. But essentially, what are the next steps? There should be a hearing conducted, and the judge may have to call at least one of the jurors back to testify about what their votes were. Okay, so first and foremost, number 2, dismiss counts 1 and 3 with prejudice due to the jury's decision. That's easy. Number 3, after they come back, they testify. The state can decide, the Commonwealth can decide whether or not to retry count 2. Double jeopardy would then inhibit the state from moving forward on charges 1 and 3. This is wild, folks. This is absolutely wild developments. Now, they, of course, the state, the government, the defense has already filed a motion to dismiss, and I imagine motion to dismiss counts 1 and 3. I haven't gone over it yet. Ted Daniels has been posting it. He posted pages 1 through 8, so I still don't even have all of them. But how can they acquit on second-degree murder and leaving the scene, but still some of them want to convict on manslaughter while operating under motor vehicle under the influence? It makes no sense to me at all. I can't like wrap my head around it. Joan Feather, welcome to the channel. Thanks for coming on. When are you going to quit calling beautiful Chandler my girlfriend and start calling her my fiance? I thought you were going in a different direction there because everybody's like, stop calling her your girlfriend. She has a name. I'm like, her name is future Mrs. Larry Foreman. I'm going to take everything away from her. Oh, it's so great. And we laugh about it all the time. She loves it. She really does. I'm not even joking. So yeah, that's it in a nutshell. The next steps that should happen is call the jurors back into the courtroom, have some testimony as to what their vote was and where they stood during deliberations. Dismiss counts 1 and 3 with prejudice due to the jury's decision. And the Commonwealth can decide whether or not they're going to retry on count 2 only because double jeopardy would inhibit the state from moving forward on charges 1 and 3. And charge 2, again, remember, is manslaughter while operating under the influence of alcohol, which again, it doesn't make any sense. It just doesn't make any sense how they could. The camera is back in the courtroom, but there are no people there. So I don't know what's going on. Yeah. People are screaming, clip that, clip that. We've had this talk before. We've talked about this. I don't know. I don't think I'm that funny, but I'll take it. But yeah, this is just insane. This is just absolutely insane. Megan Fox is going live. She's probably live right about now. This thing is still going to go. It's going to be very interesting. This is going to be Johnny Depp Redux. We might have to like maybe go and buy a laptop or something. Because her laptop is old. And now it looks like the stream is frozen. Look at this. See this guy on the right? He's just glitching. All right. So yeah. Gosh. Karen Reed. I can't believe it. I can't believe it. The source delivered. We got insane, huge news coming out. Motions to dismiss filed. Jurors coming forward. Wow. Unprecedented stuff, folks. This is just the case that keeps on giving. I'm not even joking. Right when you think it's over, right when you think it's done, like that's it, mistrial, new trial announced, let's go. Boom, we get the freaking hammer dropped on our heads. What did the defense write? Let me take a look here. The very day after a mistrial was declared, undersigned counsel began receiving unsolicited, meaning they did not ask for these. They just start receiving them. Unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement, unanimity, that Ms. Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the 2nd degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates a dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue that the court authorized defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her, prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. That is so insane. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was in an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. In short, neither defense counsel, and I'm sorry, there's a footnote here. While the juror's note as read by this honorable court indicated the impasse was on the charges, it did not say whether the charges were on those within count 2, i.e. the multiple ways to find guilt in count 2 or extended to other counts. The affidavits attached herein indicate the former, not the latter. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all 3 of the charges. This is what I've been screaming about since the moment this all happened. I said, why didn't Auntie Bev do a poll? Why didn't she ask the jurors, hey, where do you all stand? And some people were like, yeah, I agree. And some people were like, well, you don't know Massachusetts law, Larry. You don't know what Massachusetts law, Larry. You don't know what Massachusetts does things differently, Larry. What do you got to say now? I was right all along. I was right all along. Judge Bev should have inquired, what is your split and on which charges? This is literally what I've been saying. Yes, Megan Fox is live, but we're not going to be joining her yet. We're going to finish Alec Baldwin first. She's waiting on me anyway. The following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that he or she wished to inform Allen of the true results of the jury deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder, and Juror A was emphatic that count 1, second-degree murder, was off the table. All 12 jurors were in agreement that she was not guilty of such a crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene of the accident with injury or death. Another day later, on July 3rd, 2024, this is right before 4th of July, folks, Attorney David Yannetti was contacted by 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in the case. Informant B sent Attorney Yannetti a screenshot he or she received from someone, hereinafter Intermediary B, we have a lot of parties here, of text messages that intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B. This is juror's words. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose, or even that she hit him on purpose, or even thought she hit him on purpose. Informant C had been in contact with another individual, intermediary C, who is a co-worker and friend of juror C, and joined a Zoom meeting during which juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding juror C, which was revealed in the Zoom meeting. Intermediary C. So no consideration for murder 2. Manslaughter. Started polling at 6-6, then ended deadlocked at 4 no, 8 yes, guilty. Interesting, says informant C. It was no consideration for murder 2. Shouldn't she have been acquitted on that count and hung on the remaining charge? Goes back to the jury verdict slip. That was all confusing. Intermediary C replies, well, she should have been acquitted. I agree. Yes, the remaining charges were that they were hung on. And that instruction paper was very confusing. Wow. The court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. And Auntie Bev did not do that. Here are the attached affidavits. We're in agreement. All 12 jurors were in agreement that she was not guilty of such crime. No one thought she hit him on purpose or even thought she hit him on purpose. I think that's a repeat, but yeah. Reflecting juror C's statement relayed by intermediary C that there was no consideration for murder 2 and Ms. Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate from form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. I agree, 100%. Wow. Wow. And there's precedent on this, apparently. This case called Bluford. This case is such a freaking mess, folks. Such a freaking mess. I think someone on the jury just wanted her punished for the DUI. That's exactly what I'm thinking, Tammy. You nailed it on the head. They just wanted a DUI conviction. They just were not okay with drinking and driving. They wanted some sort of conviction. They had their own personal health convictions. This is what we were getting from the notes. Remember the notes. This is so crazy. They just wanted a conviction for a DUI. They have their own like moral convictions that DUI is wrong and she should be convicted. But the DUI was attached to manslaughter. So maybe some of them were like, look, I don't want to convict her on the manslaughter. Clearly, that's why they couldn't agree. Yeah, let's see Paul O'Keefe bend out of this one. That's a good tweet. This is unbelievable. I think court is getting ready to get back. Chat, look back to the Hales with privacy issues. Okay, cool. I know what the Hales have been having some updates on John and Lynette. Apparently, John pointed a gun at a child, allegedly, and then they got caught shoplifting at Walmart. And then there was a couple other things. What is this? Is that a lamp? This is a lamp. Oh, dope. Oh, it doesn't even work. That's great. Nah, whatever. What up, Q? Don't forget to bring a towel. Yeah, Paul, do you want to retract that interview or do another one to correct your previous interview? You dumb nuts. You dunce. You monkey. You moron. You still convinced? Oh, never mind. I heard noises. I thought they were back. Is my spirit animal a moth? You like the fly from Deliverance. Ooh, lamp. I get excited by little things. It's the little things in life, you know, lamps, beds. Oh, you know how excited I get about beds? The Bob, you win the internet today. Our new only fan is Celine Dion. See, this is what you're supposed to do. This is what you're supposed to do. Something that is not moving, stationary, easy on the eyes, i.e., George wants anonymity. Anonymity. I give up. I think the word you're looking for is anonymity. Did I talk about the jury coming back in the Karen Reed? Oh, what's OHO? But Karen Reed trial, yes, I did. OJO, yeah, John O'Keefe. I find it so crazy that the jurors have a group text going. Folks, that's freaking cool. They're like they're texting each other and they're deciding next steps. So apparently the jurors are deciding their next steps. Court affidavits, media interviews, I guess we'll see. But I do hope that they are going to make the right decision when they're ready to come forward. All in due time. You can't rush the process. You can't rush the process. The process has to take its natural course. You know what I'm saying? And they were so confused by the jury instructions. They admitted to being confused by the jury instructions. That's so insane to me.
Your Honor, if I may briefly.
Yes.
Oh, now we have proper sound. Hey.
Before we broke, that issues with respect to lay opinion testimony would raise relevance concerns or relevance issues. And I just wanted to get some guidance on the court from that because we anticipate, for example, the medic, as I said, camera grip. We also anticipate people testifying that a few of the other actors on set did their own safety checks, even though those actors said they didn't think it to be their duty. And so
The last part of what you just said.
sure, let me approach, Your Honor, so you can use the lectern so you can hear me better.
Me?
Is that better, Your Honor?
Yes.
Thank you. And so at the end of the last motion, you noted that issues with respect to lay opinion testimony would raise questions of relevance. And it'd be helpful to get Your Honor's guidance on that because we anticipate the medic testifying, the camera grip testifying about issues that, for example, were not reported to Mr. Baldwin, so don't go to his state of mind, or certain witnesses testifying about what a few of the other actors did on the set with respect to checking their guns when those actors themselves said, but it's not an actor's duty. And so we want to make sure that those issues are not introduced, for example, in an opening statement when ultimately it will be proven, in our view, to be irrelevant to Mr. Baldwin's state of mind, what another actor may or may not have done under the safety guidelines, or what the medic thought about the set but kept in her head and didn't report to anybody. Obviously, that wouldn't relate to Mr. Baldwin's state of mind without the reporting, or at least there's a question about prejudice outweighing the probative value of that when it goes to state of mind. And so it'd be helpful to get Your Honor's guidance on that with respect to these issues before opening, at least. We can submit more papers if you'd like, or
No, I don't want that.
I assume not, Your Honor, but that's why I'm raising it here orally versus submitting something to you.
Okay, all right, thank you. Does the state wish to reply?
Just briefly, Your Honor. So part of the defense here is this was Hannah Gutierrez's job. This is Hannah Gutierrez's fault. The truth is Hannah Gutierrez wasn't doing her job properly, and everybody seemed to notice it except for the defendant. So it's true. We do intend to have witnesses say, I had concerns about the way that firearm safety was being conducted on set. In terms of whether or not it's relevant that other actors perform their own safety checks, I think probably just depends on how the evidence develops. I think my very first meeting with Mr. Nickus, one of the things that he explained to me is that there's a scene in the movie where the actor Travis Fimmel holds his gun to the back of the neck of the child actor. He's got his finger on the trigger and he's got the gun cocked. And Mr. Nickus said, Travis Fimmel would never have done that unless he felt safe with these firearms, unless he thought that these firearms were completely safe. Well,
I'm glad I'm not the only one who
cut
thinks
to
that tax
reality
cut.
now. The truth of the
I was
matter
thinking
is
that
that
from the
Travis
moment
Fimmel
this-
was one of the guys who every single time Hannah Gutierrez handed him a gun, took the gun and dry fired it into the ground more than 6 times to ensure that he tested every single chamber in the gun. So certainly if part of the defense becomes these other people pointed guns at each other and it wasn't a big deal, then obviously it becomes highly relevant that these other actors felt free to do it, because whether it was their obligation under the safety bulletins or not, they understood that that was a smart thing to do, especially when you've got this armorer who doesn't seem to know what she's doing.
All right, thank you. Oh, go ahead,
Just-
reply.
just-
Yeah.
Just some clarity, Your Honor, because what I think it would be helpful, both so we can get the court's guidance and so we can understand what kind of case they're putting on, if they give an offer of proof of these issues. Because, for example, if the medic comes in and says, I had safety concerns about on set, that's an opinion about the set that wasn't communicated. It's not to say she can't say, I saw Ms. Gutierrez running around, I saw her doing this, she was moving quickly. Those are facts. We're not trying to get out facts unless they turn out to be more prejudicial, they're probative, unconnected to state of mind. But her opinion about the safety of the set, that should not be included. That's irrelevant.
She doesn't get to do opinion. I already ruled that.
Exactly, Your Honor. And so what we just heard from Ms. Morrissey is, well, maybe it's relevant that an actor checked the gun on set in a different way for Mr. Baldwin, or he checked the gun at all. Maybe it's not. And so to actually get guidance from Your Honor, so we know what this case looks like when we're going into opening statement, having an offer of proof on these issues, I think will make sure that we don't end up having irrelevant testimony included, that we don't end up in the middle of opening talking about something that the state is or is not going to do with respect to these important evidentiary issues.
All right, so to the extent of looking, I don't think I can't remember the people that testified in Hannah Gutierrez, but one was somebody that walked off the job, okay? And I think he has a
Lane
pending,
Looper, Your Honor, yes.
He did not testify during Gutierrez, Mr. Nickus.
Lane Looper walked off the job,
well,
but he didn't testify.
somebody that was like the head camera guy walked out and looking at Ms. Morris because we were in the case. But so if he were to testify that I left the job because of safety concerns, that cannot just, it has to be related to what you're trying to prove. So it would have to be related to Hannah Gutierrez. I'm not sure where I see, that's off the top of my head that it would have to be related to Hannah Gutierrez and them observing that this armor was doing a sloppy job, and when they observed other armors, just pretty much what they testified to before. But if they're going to say things like nothing that would speak to him as a producer cannot come in.
Understood.
So if you're going to say, look, this person was sloppily handling the weapon and it doesn't relate to Hannah Gutierrez, then that's producer. That's not actor. Am I being clear on that?
I'm a little confused.
Well, I'm trying. I don't know. I don't remember the scene that you used, but let me just say this. So you're saying, that this actor had to check because he didn't trust Hannah Gutierrez. Okay, that's Hannah Gutierrez. Okay, but let's say the shooting, Sarah Zachary. Okay, when she shot, there were 2, and Sarah Zachary shot on the ground or something like that. You would have to tie that to Hannah Gutierrez because that's producer issue.
So let me see if I can help out a little bit in terms of narrowing this down. I do not intend to put witnesses on the witness stand and have them say, generally I felt unsafe on this movie set. I intend to have witnesses say, these are the things that I saw with regard to the handling of firearms that caused me to feel concerned. And in terms of an offer of proof, all Mr. Nickus has to do is just go read the transcripts from the Gutierrez trial that he's been shoving down my throat for the last 5 months, because that's what I'm intending to have the witnesses testify to. This is what I saw, and this made me feel uncomfortable, and it goes directly to the defendant's defense of not my job, she was great. I had no reason to
Yes,
doubt.
but it has to be related that Hannah
Right.
Gutierrez's
Agreed.
job as an armorer. You can't just say, I felt unsafe because people were screwing around with guns. Because that might not be related to Hannah Gutierrez.
I agree with you.
Right.
It has to be related to Hannah Gutierrez, or it has to be related to Mr. Baldwin's handling of firearms, which is directly relevant. I agree with you absolutely.
In one clarification there, Your Honor, October 8th, 9th, for example, Mr. Baldwin's not there. If someone testifies on the 8th, I saw Hannah do X and Y and Z, and I felt very unsafe based on what she did, they not only have to connect it to Hannah respectfully, but they also have to connect that to Mr. Baldwin. Because if Mr. Baldwin didn't see it, then this comes back to the imputed producer theory. He must have known safety issues on the set on the 8th, but they haven't demonstrated that, and they have to demonstrate that to have any relevance to his state of mind.
Well, I'd have to hear what it was.
Of course, Your
You
Honor,
wanna
but
tell me?
that's an example.
Oh.
If a witness comes in and says on the 8th, when Mr. Baldwin was not there, I saw Hannah Reed do something quickly or act unsafe, that relates to Hannah, but it's not relevant to Mr. Baldwin's state of mind or his knowledge of Hannah. If they say on the 20th, I saw Hannah acting carelessly, here's what she did, she moved real quickly, Mr. Baldwin was there, he saw that, then that's fair game. That's my point.
Well, what you're saying is that the state can only introduce evidence that Mr. Baldwin was aware of, and I'm not sure that's correct.
If they're going to show that there was a safety issue on set with respect to Hannah Gutierrez on October 8th that Mr. Baldwin did not see or know about?
I don't know.
Okay.
Because the other way you could do this is that he was, with respect to, for example, David Halls, and how, you know, he said, well, he periodically checked the gun. And I'm not sure whether there was some kind of, I don't know how to put this, some understanding about how she was doing things that could be cumulative. I don't know. I would have to figure that out when it's offered. And I'm sorry.
No, the context is going to matter here, Your Honor. I just wanted to flag this issue because seeing the transcript in the Gutierrez trial, we did see the state try to introduce some of this, and we want to make sure it's connected to
I
Mr.
know,
Baldwin.
right, Time Lord
We don't
Cloud?
want a trial within a trial,
I like her a lot.
Yes, Your Honor.
but we also want the state to be able to address that, you know, their theory that he should have checked the gun.
Understood, Your Honor.
Okay,
Thank you.
I hope that was helpful.
It was.
Okay.
And it'll come up and we'll ask
Yes,
for more guidance
absolutely.
when it comes
Okay.
up more
All right.
precisely.
Okay,
I think I probably stand here, Your Honor, right? We've got the next in limine
yes, we do.
on
Okay,
inconsistent statements. Is that right?
no. Oh, yes, no, we already did the lay witnesses. This is motion in limine 5, previous contradict the state's. Let me use my list.
I think that's right, Your Honor.
Okay, we've done their 6, got to their 6. And
And there's 7, I believe. Sorry.
no,
Or 5 and 6, I'm sorry. So
okay,
we're back
that's
to
all right.
5.
Let's see. So we're on 5. Okay. Defendant Alec Baldwin's motion in limine to preclude argument and testimony that contradict the state's previous factual assertions. Go ahead.
Thank you, Your Honor. So I'll make this brief. In the Gutierrez trial, the state made a handful of important statements that relate to what Mr. Baldwin did or did not have an obligation to do, or the cause of the underlying harm. For example, said Hannah Gutierrez Reed is the autonomous decision maker. Or if Hannah Gutierrez Reed had checked the gun again, it wouldn't have made a difference. Or the training or not of Mr. Baldwin with respect to the gun is not why Ms. Hutchins died. It's because of Hannah Gutierrez Reed. and so forth and so on. We put them in the brief, Your Honor. Those statements contradict a number of different elements of how the state has argued this case in the past. And we expect that those will contradict how the state intends to present its case this time. Two things. Number one, the case law is clear that the obligation of the prosecutor is to pursue the truth and not convictions, if there's a difference between them. And so the case law recognizes that it violates due process for a prosecutor to present contradictory theories across two trials that relate to the same matter. Now, they're not bound by the precise theory or the precise factual, underlying theory, legal or otherwise. The cases they cite are cases like Fry, where there are two defendants. The government doesn't know who actually shot the gun and killed the victim. And so it puts on a trial saying this one did and then this one did, because the government doesn't know. Those aren't internally contradictory.
Can I interrupt for a second? Aren't you rehashing what has already been done?
We're not, Your Honor, because the case law is clear. We can use those statements as party admissions. For example, look at the Bradshaw case.
Okay,
that the state.
just a minute. First of all, that's not in your brief.
It is, Your Honor.
No, just a minute. You're not going to be able to argue what Ms. Morrissey said as a statement of what the prosecutor said in that case. There's a case, I thought this might come up and I should have pulled that case, but Justice Chavez did it, and it's contrary to U.S. court case or federal court, because it doesn't allow that in.
There are two different issues here. One is, does it violate due process to do it? And the other is, are we allowed to present the state's contradictory statements?
So I already ruled it didn't violate due process.
Right. And so on the second, and that's what the cases say. That's what Your Honor is referring to. And the case in the Bradshaw case that the state cites in its brief, it says, look at Justice Thomas's concurrence. Justice Thomas said the Supreme Court has not ruled on, and he wouldn't support a due process violation.
Mm-hmm.
But then you have to continue reading that concurrence that the state cites. Justice Thomas says, if the prosecutor makes inconsistent statements, that risks undermining his case, because the defense counsel can present those contradictions to the fact finder, quote unquote, or close enough, to the Thomas concurrence. And in that concurrence, Justice Thomas says, involving two different defendants, agrees with Justice Souter, says the defendant in the second trial can present those contradictory statements that were made by the state in the first trial to the fact finder, and the fact finder can weigh those inconsistencies as it will. The state does not cite, and that's directly from the Thomas concurrence that the state cites. We're not saying due process. We do argue that. We want to preserve that. But we should be able to present. In fact, their own case says we're allowed to present those inconsistencies. On top of that, the state does not cite a single case, not one, that says we're not allowed to present those contradictions in this case. Not a single case. They say it'd be prejudicial. But their statements, clear as day, what they said.
Let me find this case, because it went to this. But okay, I'm listening. All right.
And they say 403, but Your Honor, they don't cite a single case that actually allows them to say X in one trial and then show up in a related trial and say not X or contradicts the X. And we're allowed to present that. That's their own Thomas concurrence. In the U.S. versus Small case, for example, that talks about 403 and prejudice, says extraordinary remedy. They don't cite a single case for it, and they're asking for an extraordinary remedy. And all we're asking for is that the statements that this own prosecution made in this court, as an officer of this court, as Justice Thomas says we're allowed to do, present them to the fact finder here. Thank you, Your Honor.
All right, thank you.
Seems reasonable.
Your Honor, with respect to the introduction of what are they're calling inconsistent theories, the U.S. versus Ganado Negro case addressed that specifically. that some courts recognize that while due process may prevent the prosecution from presenting inherently factually contradictory theories in different trials, there are those circumstances where there are evidentiary disputes about responsibility for a crime, for example, among several defendants. And in the Ganado Negro case, the court specifically recognized where there are cases where there are multiple defendants, as long as the prosecution doesn't present false evidence or factually or facts that are inconsistent, they can present theories that are different. And that's essentially where what the Ganado Negro case held. With regard to the admission of Ms. Morrissey's statements, Your Honor, we would be creating a trial within a trial. We would respectfully ask, now, while the court is correct, federal case law has noted that statements by a prosecutor in previous trials may be admissible as admissions by a party opponent. The state, I would submit to this court, is different, and this court can exclude those statements. This would be essentially Ms. Morrissey having to defend her previous statements. We're going to be doing essentially a trial within a trial, and we'd ask that the court exclude any statements made by Ms. Morrissey. And if I may just have a moment, Your Honor, I think I can pull that case that the court was referencing. But under Ganado Negro, the state should not be bound to the exact same theory of prosecution that it followed in the Gutierrez trial. This is a different trial. The facts are slightly different as they relates to this defendant's culpability. Unless the court has any questions, Your Honor.
No, I want to find that. It's not, it can be dispositive on other issues, but I want to find that case. I should have just pulled it.
Your Honor, if I may.
Yes.
Two things. As a precaution, if Your Honor would like to reserve on the issue, we can take a look at the case. You can hear a few minutes of additional argument after we've read it. That might be prudent, respectfully. Number two, you heard Ms. Johnson say, it's going to be a trial within a trial. It's 3 statements, 4 statements. The state made them. You just heard her say that the case law allows us to introduce the contradiction. She didn't cite a single case saying otherwise. She said it allows that. They've admitted that. Due process aside, that's the Garnegro case that she cites. If they want to present an inconsistent theory, then obviously we reserve and preserve the due process issue. But if they want to raise an inconsistent theory, then by all means, Justice Thomas says they can do that in his view, but you're allowed to show that it's a contradiction from what they said before.
All right, thank you. Well, that doesn't mean the court has to, so we'll take a look at that. If you could find that, it was Justice Chavez. All right. Okay, we're on. Steve. Okay, state's motion in limine 7 to prohibit use or testimony of OHSB summary of investigation.
We have attached as an exhibit the summary of investigation that it seems clear that the defense would like to have admitted as an exhibit. So I want to address 2 issues. One, should the summary of investigation be admitted as an exhibit? And 2, should the findings, which I would argue are legal conclusions, be allowed in as testimony?
So we've got the summary of investigation is hearsay. The public records exception to hearsay it was never intended to permit something like the summary of investigation to be admitted as an exhibit because it contains legal conclusions. It's actually findings and conclusions. That's what they call it. It contains legal conclusions. It is based on a law enforcement investigation. That's all OSHA does. OSHA enforces the Occupational Health and Safety Act. And in addition to that, the summary of investigation, as you can see, has numerous instances of hearsay within hearsay. And while the defense responded and said Ms. Morrissey hasn't pointed any of those things out to the court, well, they're all highlighted in the attachment. So yes, it's true. I didn't cut and paste everything from the attachment into my motion in limine, understanding that we do have page limits that the court has been concerned with. I can pull up the exhibit and I can certainly go through all of the different quotes where OSHA investigators say they actually put people's statements in quotes during the investigation. So that's hearsay within hearsay. Those quotes don't come in. The findings and conclusions are legal conclusions. So those don't come in because we can't have the jury hearing that Mr. Montoya and Mr. Genoway came to these conclusions because it's going to cause the jury to think that they now have to come to the same conclusion. The problem with the OSHA report generally is that, one, they didn't do a very complete investigation, and I outlined very specific instances of where their investigation fails. And in addition to that, every time I read the OSHA summary of investigation, I say to myself, what is the relevance of this? What does this have to do with the case against Mr. Baldwin? And I want to put kind of in perspective, admitting not only the report, but testimony about the report is like let's say we're having a DWI trial and it's a jury trial, and the jury gets to hear about the MVD revocation hearing. That's kind of what this is, only the MVD revocation hearing would actually be arguably more relevant and possibly more admissible than the OSHA, because OSHA is not concerned largely with the conduct of individuals. As you can see, Judge, the OSHA report basically says Hannah Gutierrez didn't do anything wrong. Well, we know Hannah Gutierrez did something wrong. We did an entire trial about it, and a jury convicted her in 2 hours. So it has nothing to do with the charges against Mr. Baldwin. Now, having said that, can the state or the defense call these witnesses that were interviewed by OSHA, put them up on the witness stand? Mr. Halls was interviewed, Mr. Baldwin was interviewed, Ms. Gutierrez was interviewed, numerous witnesses were interviewed. Can we call them and put them up on the witness stand and then refresh or impeach them with the statements that they gave to OSHA? Absolutely, as long as the testimony that they're giving in the witness stand is relevant to the issues in this case. And I'll tell you, on its face, I don't disagree with the findings of OSHA. OSHA found that Rust Productions was responsible under the New Mexico Health and Safety Act for allowing this hazard to be happening on this workplace. I completely agree with them. That doesn't have anything to do with whether or not Mr. Baldwin is guilty of manslaughter. The other thing that I want to point out is the defense wants to do this thing where they don't want you to allow us to bring in anything about Mr. Baldwin being a producer. But what's critical about the OSHA report is the OSHA report says it was the fault of the bosses. It was the fault of the producers. So if the OSHA report gets to be discussed and we get to hear testimony from Mr. Genoway and Mr. Montoya about the fact that this death was the fault of the producers, then we absolutely at that point get to point out that he's one of them. And he was in a position where he got to do whatever he wanted because he was a producer. So if the court is going to prevent us from raising the issue of Mr. Baldwin being a producer, and I respect the court's ruling, absolutely, then the OSHA decisions can't be discussed because they go directly to the fact that he's a producer. And that will open up this issue that I've had with Mr. Montoya in the past, where Mr. Montoya came up with this kind of fake notion of Mr. Baldwin's a producer, but he's not really responsible for anything other than creative. And Mr. Montoya came to that conclusion because he never looked at the contract and he just talked to Mr. Baldwin. When you look at the contract, and I put the language in our response, or I'm sorry, in
We
my
are known
motion,
for that.
he's absolutely a full producer. There are no limitations on his role as a producer. The language in the producer contract says he is expected to fulfill all of the duties traditionally known by movie producers. It doesn't say there's any restriction at all. So we've got some difficulty here because if they want it in, then producer comes in. If it stays out, producer stays out. So I would ask the court to look at it in that way. If OSHA comes in, the fact that he's a producer becomes highly relevant at that point in time. Thank you.
Three quick points, Your Honor. Number one, we've cited cases saying it's admissible. 8038C says if it's a criminal case, there's a factual finding, and it's a legally authorized report, it comes in under the hearsay exception. We've cited cases on that. Number two, Jorgensen, their expert witness who's going to testify under Your Honor's ruling as to the safety.
He's not an expert witness.
Jorgensen?
No, he's going to just testify about the guidelines. He doesn't get to provide an opinion.
Right. That was already
Your Honor,
decided
Jorgensen
earlier.
has no factual knowledge of the rest set. What he,
Wait a second. Jorgensen is the guy with the SAG guidelines, right?
that's right. He
So I ruled that he gets to testify about the SAG guidelines, but he doesn't get to provide an opinion about the safety.
That, correct, Your Honor. And one of the issues is that, and we may use it or we may not, but when he was asked at his pretrial interview, what did you do to prepare for giving your opinion? He said, well, I didn't talk to anybody, some hearsay. I read the OSHA report a lot because he's an OSHA guy. That's his background. And so to the extent we think it's necessary to raise that, then that would be the limited context number. And so ultimately, because it's admissible and because it may relate to their witness, we may have to raise it. And so that's the context in which it could come up. Number three, just for clarity, the report didn't say the producers are responsible. It said Rest Productions LLC, that's one person's company, is the employer, and the employer, not Alec Baldwin, the employer is the one that is being fined under that report. And so there's a very big difference.
But Rust
between
Production
saying Rust
Companies
Productions
LLC
is responsible for violating these OSHA rules and saying
Isn't that Alec
Alec
Baldwin?
Baldwin is a
Isn't that
producer and he had a
synonymous?
contract with Rust Productions,
Isn't that
therefore
just
he's responsible. It's not all the
skirting
report
it?
said.
I
So
don't
these
know.
are not linked in the way that Ms. Morrissey described. Nothing
It's like me saying like Foreman and Associates is not Larry Foreman,
I already ruled that.
which is true. I mean, it's funny.
Producer liability or whatever.
It is
does not
funny. I
come
guess
in.
it does work,
So
doesn't it?
this OSHA report is specifically prepared by OSHA to go in and investigate whether the employer had any responsibility, and they were in fact fined. If that testimony comes in and by oral and including written, then you have opened the door to producer. And with respect to you saying that the only reason why we may bring it up is because Jorgensen may mention it. Jorgensen's not going to mention it because I already said Only safety guidelines, okay?
Next,
Okay, so that's granted. I want to keep track of my
statements
omnibus
allegedly made by the
order.
victim. Is that next?
All right. Defendant Alec Baldwin's motion to eliminate to preclude argument, evidence, and testimony regarding the victim.
Yeah.
Thank you, Your Honor. We addressed this briefly earlier when I withdrew our request to admit the medical records. It's axiomatic and not disputed that a victim's good character and all the wonderful things about them is not relevant to a criminal trial. They don't really dispute that. What they do is they try to sort of come up with ways to backdoor that evidence by giving other reasons. Like they say, well, we need to explain why Mr. Souza hired Ms. Hutchins. And so Mr. Souza needs to explain all the background about Ms. Hutchins in order to explain his hiring process, which is, of course, completely irrelevant in the first place and an obvious backdoor and not particularly intellectually honest. Then they say, well, the reason we have to explain where she was born and how she grew up is because there's one moment in this case in thousands of pages in which one witness mentions that she speaks Russian to another witness. So in order to understand that, you have to understand where she grew up in Ukraine and all of that, and her childhood and all of that to understand that. And of course, that's also intellectually dishonest. And all you have to say, if you care about making sure this court is and this jury does not, decide this based on emotion and sympathy and the wrong reasons, is you have to say, did she speak Russian? Yes. Did you understand she understood Russian? Yes. You don't have to go into the 30 years of history here. So that's the way to deal with that. In terms of exhibits, it's also very, very simple. They talk about the lapels. I agree with them. The lapels at the scene are relevant. You don't show the positions of the bodies on the ground. It's not relevant. It's not in dispute. It's not a fact in dispute. It doesn't tend to prove anything. I agree with them. The autopsy is relevant, not the photos. The photos don't help anything. The person who's doing the autopsy is more than sufficient. And let me say something else. And this is why I wanted to quickly withdraw the application for the medical records, which is we don't dispute anything about any of this. This is not an issue in this case. You will not hear us cross-examining or questioning the fact that she passed away or the cause. In the other trial in which you presided off, there was at least some testimony, some indicia that they intended to proceed that way. And maybe that had something to do with why so much of that evidence came in. That is not an issue in this trial. It's just not. And so every single time that evidence comes in, it's wholly irrelevant because I've just told the court we're not making an issue of it, and it's extremely prejudicial. It is the most extreme possible weighing of the scales that one could ever have because it is completely irrelevant because I'm saying, I agree, she passed away because of this. So, and their real reasons for doing this is obviously exposed.
Okay, so you're sort of combining everything. Why don't you go through each one that you identified?
Sure. The character of the deceased victims I just did. The moment of death and subsequent pain is obviously completely irrelevant. The emotion, they say in here.
Did you say completely relevant?
Irrelevant. They say that the reason that they're eliciting it is to bolster witness credibility. That is a per se improper reason. They say that they say evidence is relevant and it explains a witness's conduct and bolsters. They're using emotional sympathy, drama of something to bolster a witness's credibility. The fact that she suffered might be irrelevant or admissible in a wrongful death case. It's not an homicide case. It's nothing to do with it. Nothing. And to the idea that they're going to use it so that the witness is upset on a witness stand and saying, and this is how she fell and her face was pale and this, and now everybody's upset. And trust me, I saw what I saw about something relevant is exactly what a court can't allow. It's exactly what a court can't allow. And they did this the entire trial with, and I mentioned this before with the, where is she now? Is she in the medical vac? They ask all of these, why is even one time, the tone of her skin as she falls, why is that possibly relevant to this trial? And they do it with every single witness they did it with. So then you get to the lapel cameras and the autopsy photos. And so I was trying to track this precisely. Again, we agree that the lapels of the scene are relevant, right? You just don't need to show a body on the ground. It's just not necessary. And the autopsy photos are particularly problematic. They don't show, how are they relevant? We could stay here for days and no one could explain to me how the autopsy photos are relevant. They're not. If the court wants to voir dire the medical examiner and say, is it possible for you to explain this without presenting these graphic, vivid depictions of a tragically killed person? They're going to say, of course I can. Autopsy photos get ruled out all the time, especially in cases like this. This is not, a whodunit where it's like, okay, let's look at this, but I'm saying I didn't do it. This is a tragic accident where two people who are known to each other and no animosity towards each other, this occurred. And so it doesn't have anything to do with the case or anything relevant. And I'm telling the court that we're not making an issue of this. So if the court knows that, unlike in the Hannah Gutierrez retrial, that this is not in dispute, I really don't understand the basis to allow a single witness to do any of that, a single witness, let alone the cumulative every single witness, which is just being done to taint the jury and to try to get the jury to do something on sympathy. Thank you.
Yeah, that's a good argument. Let's see what the state says.
The state has no intention of presenting evidence related to Ms. Hutchins' childhood. So we can eliminate that right off the bat.
What do you plan on?
Well, we believe that there is limited testimony from Mr. Souza that's appropriate because jurors don't know how the film industry works. He should be able to take the witness stand and say, as the director, I got to pick my director of photography. Here's what the director of photography does. These are the reasons I picked this person. We're not going to have him talk about, she's an honest person. She's an amazing mother. She's an amazing wife. None of that's coming in. But he gets to tell, we get to put the story in context for the jury. And I think that we can do that without doing all of these things that the defense is claiming are so highly prejudicial. I have no problem limiting that testimony with regard to Ms. Hutchins, but certainly the jury gets to hear what she did, how she was hired, how does this come together? How do all of these people come together on this movie set? That's absolutely relevant. Now, with regard to the lapel videos, the defense says, we think the lapel videos are relevant, but we just don't want the jury to see the human part of it. And that's kind of hard for the state because we kind of have to prove that a human being was killed. That's part of what we have to do here. So the other thing that you have to understand is that the defense probably is going to take a similar tactic in this regard that we saw in Gutierrez. And they're going to question all of the law enforcement officers about, why didn't you do better? Why couldn't you have done this? And why couldn't you have done that? And the answer is, this was extremely chaotic. We've never shown up to a crime scene where there were 150 witnesses there. There were people mulling around everywhere. There were things that we had to do. Those lapel videos show how difficult and chaotic that scene was, and it goes directly to their defense. And listen, I mean, they act like these lapel videos are like a horror movie. You see Ms. Hutchins on the ground, you don't even see blood. You don't even see blood coming out of her.
You see, Mr. Souza's yelling because he got shot in the shoulder. That's not overly prejudicial. Absolutely not. There is tons of case law where, and the lapel video of them laying on the ground is very, very similar in terms of the analysis as the autopsy photos. Autopsy photos come in. They do. They come in every single case. I have never had a case where autopsy photos were excluded. And I even cite to a case in my response where the court actually says, basically, we've never heard of a case where there was a reason to exclude these. They just come in. Now, listen, I want this court to know that
I don't like her
during
attitude.
Gutierrez and during this trial, there are autopsy photos in this case that are shocking to the conscience, that we could argue successfully are relevant. Because when you crack open somebody's body, you can see
and listen like
how the bullet
to a
traveled.
judge.
And autopsy photos actually show that. We're not asking to get those in.
I don't like her.
We are doing exactly what we did in Gutierrez.
I don't like her attitude.
Just 2 to 4 very benign autopsy photos. We have been more than reasonable in terms of trying to turn down the volume on emotional response with regard to these autopsy photos. I was actually stunned to see this motion after we exercised so much restraint
Not a people
during
person.
the Gutierrez trial. And those are the same pictures. We haven't upped the ante here. We're not trying to show anything other than, look, this is where the bullet entered. This is where the bullet came out. Those are relevant. Those are relevant to Dr. Gerald's testimony. Those come in. They come in every single trial. There's just a reality associated with the fact that someone died. I am more than surprised to hear Mr. Spiro come up here and say, we are not disputing the cause of death. The whole reason that we have probably 4 or 5 witnesses on our witness list is because the defendant put Dr. Bianca Alvarez on their witness list. They called her, talked to her on the phone without inviting us. And the whole point
They don't have
of doing
to.
that has to do with this farce defense of she didn't die of a gunshot wound. She died because she wasn't intubated properly. So I want to say right now, because we're short on time in this trial. If the defense is not intending to make any arguments that she died because of a faulty intubation, let me know, because I can shave a lot of witnesses off my witness list that way.
Interesting.
Thank you.
Thank you.
That's a good point, actually, as well. I don't know. This is a hard one.
State did not address even slightly in either their motion papers, in the Hannah Gutierrez retrial, or in that response, anything about how ashen she is or how the moments happen after matter. They don't. They didn't address it in their papers. They didn't just address it now, right? So I just want to make sure that the court, as the court was well to point out to me, demark these issues. They have not addressed that. There is no dispute that that's not possibly relevant to talk about how the person was dying and what their skin looked like and their breathing. It's just not relevant. They then go into this, how Mr. Souza selected her to understand the film industry working. I mean, Your Honor, it's like they don't ask a single other witness, right? Well, how did you get hired? And why did you get hired, right? I mean, so I'm sure that the court sees through this. If somebody were to say to me, this is the one question and answer, and there was an offer to proof, I'm sure we could work this out. But how can I possibly trust this process if we don't hear that exactly because of what I've seen? And then I'll just deal with the autopsy photos. Again, we're stipulating to identity and that she's deceased, and that we're not saying that some other causal factor killed her. So this makes the balancing test very, very easy. That doesn't happen in every homicide case, right? And also, I wasn't, I don't say these things in front of juries, but I actually prosecuted homicide cases. No, and often there is a discussion over, they don't always come in. And often there is this thing where sometimes prosecutors want to put them in to gin up the jury, and judges make calls all the time that it's just not necessary. We don't need to remember her that way. We don't need to do that in this case. I don't need to do that in this case. And this court can very well, like the court said to me when this hearing opened, take order of the court and has the discretion to say, no, pictures of this tragic dead body is not necessary here. I'm telling the court again, I'll say it now, I think a second time, which is we are not making an issue out of the cause of death, period. They want to take these people off the witness list, they can. But if that's what we're doing, and I've withdrawn our seeking the medical records, then I've left the court with very simple, in my judgment, balancing test. And I'd ask the court to really think about when this verdict comes down, having faith that this was a fair trial and the verdict was based on the right reasons. You can't have, it's hours of testimony, hours in the Hannah Gutierrez Street trial about it. And it's different here because the gun was in his hand. The gun was in his hand. So to allow hours and hours of testimony, when we have, the state has 5 days to present this case and we need the opportunity to rigorously cross-examine, it doesn't make any sense. I don't think it's fair, and I don't think the court should allow it. Thank you.
All right, the court makes the following ruling. All right, with respect to the character of deceased of the deceased, certainly if Mr. Baldwin was going to get up, you'd want to go, how did you come about getting this this job, so to speak? And I think it's just an introductory way to tell the story. Now, I do remember Mr. Souza going into, we met, I liked her, we had things in common, et cetera, et cetera. I think all that needs to be said is that she was one of some choices. He felt that she was a good fit and that she was the director of photography. That's it. Okay. Now, with respect to the moment of death and subsequent pain, I think that does go to the death. That's one of the elements, and the death and the injury, the death. And I do think that that makes a fact more probative, and that is the death, and that I don't think that is its probative value substantially outweighed by unfair prejudice. Having said that, I'm trying to recall everything that occurred regarding that, and I do think that the video is appropriate. Now, I think there were some people that got up, and this may be what both of you have referred to, where they talked about being upset. They talked about, how upsetting it was and things like that. We don't need that. We just need the lapels videos as to what happened with respect to her being shot and Mr. Souza being shot as well. So that's the lapel camera depicting the crime scene. Am I misunderstanding anything else on that?
From the defense's perspective, a lot of this also goes to 403 and cumulative list, right? So
could you just answer my question? Okay.
yeah, well, I think the answer
I don't want
is
you to
yes.
argue again. You already had your chance.
I think the answer is yes, Your Honor. I'm not, if I understood the court's ruling, I think the answer is that yes, if the lapel videos are the way that they're going to show where the bodies were or the
This is
manner.
when Lieutenant Benavides is in there and he says, "Everybody clear out." Is that the video?
And primarily also Officer LaFleur, who's the first officer on scene, that video
Right,
also.
where people are rendering aid.
Right.
All right, so that comes in. Autopsy photos, again, you can stipulate, that's fine, but they're allowed to tell their story and they're allowed to demonstrate the death. I do remember there was an autopsy photo that was pretty much agreed it was prejudicial, or maybe it was somewhere else where her shirt, I think. Which part of the autopsy photos? I don't know. But the autopsy photos in my mind are the body.
So just to iron it out right now, we've got pretty much the same photos of the body that we showed during Gutierrez, nothing overly dramatic. And there is a photo of the bloody clothing, and part of the reason that's relevant is because her cause of death was exsanguination, so she bled to death. So the photos of that amount of blood go directly to her cause of death.
I will allow that. All right. You can revisit that defense, but I do anticipate you may bring up some information about the tubing.
Just to say that there, and I know the court has one more argument, but the court's looking at me for guidance on this. That we're not going to do that. We're not maybe going to do that. We're not going to do that. So when we say that we're not going to do that, the court can count on that, and that makes those.
Well, you didn't say that. That's not.
Oh, I thought that's what I was going to address.
You could ask the doctor. You said you didn't care about the UNM records, but that you didn't say you weren't going to ask the doctor.
If I wasn't clear, I'll make it more clear, which is we are not going to ask the doctor about that. So if we're not going to ask, we're not going to seek to introduce medical records, and we're not asking the doctor about that, there isn't a basis of relevancy anymore. There just isn't. And so I'm asking the court that they now have several ways the court has just allowed for them to present that this was a death, which we concede. So, right?
All right, that's fine, but they still get to do it. I'm saying no to you.
Right.
All right, so let's not do the shirt if they're not. Well, no, I'm going to allow the shirt. You said that she bled to death. There's nothing wrong with that. All right.
And I'm gonna start calling off witnesses then to testify that she was correctly intubated. Are we clear that the defense is not going to raise that issue?
We are not raising that issue as to the cause of death, and we maintain our objections to the exhibits, and we understand the court's ruling.
So, just to be clear, the video, and all I'm remembering is the video. Okay, so if there's something else that comes in about in the church, then we need to revisit this, because I am making a ruling about the video. I don't remember if there were any photos. I don't think there were photos, but I remember the video. Okay, they get to put on what the church looked like. Secondly, and also that gives an understanding of where Mr. Souza was for various reasons. Then, with respect to the autopsy photos, I'm not sure whether that shirt is more prejudicial than probative. You can get out that she bled to death in different ways. I'm not sure that that's necessary. I'll revisit that.
Okay, and what I can do, Judge, if it helps, I can email copies of the photos to you so you can look at them. I mean, Dr. Gerald isn't scheduled, the photos come in through Dr. Gerald, and she's not scheduled to testify until the end of our case.
I don't want to revisit the autopsy body
No,
photos.
I hear you. I can send you, and I apologize. I understand why I just.
Why is this lady so
got my
off-putting?
wires crossed. Some of the photos of the bloody clothes were taken by OMI. So what I can do is I can email to you, and of course CC the defense, those photos of bloody clothing so that you can look at them and you can make a determination long before the witness ever takes the witness stand, what's appropriate and what isn't. Understanding autopsy is something different. You've already ruled on that.
All right, thank you for that.
Your Honor.
Yes, I have law talk.
If
We
we may
talked
go
about it.
back to the state's motion, defendant's motion on limiting number 5. I found the case that the court was referencing.
Okay, what is it?
It's State versus Montoya. It's 2016 Westlaw.
I like this one so much better.
39984.
The one in the gray
It is a
jacket, she's
Justice
so
Chavez
nice.
opinion, and the issue begins in at paragraph 42 and 44, where the court did not allow the defense to introduce the prosecution's opening statements or statements during opening in a previous trial.
There's two State versus Montoya's.
Yes, Your Honor. This one is it's a Westlaw site.
Oh, I see. Okay.
It's 2016 36399. Oh, sorry, I just lost it. Let me go back. So it's 2016 Westlaw 3639984, and it's Justice Chavez opinion.
And Your Honor, we can take a look at that in the break as well and give you our views, if we may.
Mm-hmm.
Thank you.
Just wanted to see if it was the one I remember. Okay.
That was the reference to opening statements.
That was the next one up.
All right, state's motion in limine 8 to allow use of exhibits during opening statement.
Your Honor, we don't have I think there's a way to shortcut this, which is that as long as the defense can also put in exhibits and the court will, if there's any issue between the two sides, address those one or two issues. I'm hoping that there's not. We would not, as long as it's equal to both sides, we would not have an issue.
Are they going to be admitted?
Yes, Your Honor. In fact, I provided defense counsel this morning a copy of the exhibits. I have a copy for the court if you'd like to look at them. What I would request is that they provide
way too
us
excited, though.
today with a copy of the exhibits that they intend to introduce in
All
case
right,
there are
but do
any
you
issues.
think there's going to be an issue on admission at trial?
No, Your Honor.
I don't believe there's of the exhibits that we're putting forth. We're putting forth basically the same set, a little bit more of a videotape or a little less, and the 911 call. That's it. So there's very few exhibits that we're using at opening, and I don't think any of them are an issue.
All right, well, I want you all to agree because I do not want us to stop in opening statement. Okay?
Yes, Your Honor.
So if you don't agree, let me know.
Yes, Your Honor.
All right, defendant Alec Baldwin's motion limited to preclude argument, testimony, and evidence related to the incident from the Crow.
Thank you, Your Honor. We move to exclude the state presenting evidence of what happened on the Crow as evidence of Mr. Baldwin's state of mind here. The state has said it will not present evidence of what happened on the Crow, but what the state did say is it intends to address and present the theory essentially from the Crow that blanks can kill. Mr. Baldwin knew that, and therefore he's responsible for having the criminal state of mind necessary to prove involuntary manslaughter here. There are 4 problems with that, Your Honor. The first is, let's go back to the indictment. The indictment says that Mr. Baldwin is being charged because it was foreseeable to him that if he didn't check the gun for live ammunition, it says nothing about blanks, not a single word, then his use of the gun by pointing it and pulling the trigger, they allege, could cause significant risk of harm to human life. That was the theory of the indictment. Live ammunition, nothing about blanks. A few witnesses mentioned here and there blanks in the context of an accidental discharge. They get loud, you have to put your goggles on, your earmuffs on, people get mad. There is no testimony in this case about that blanks kill in this particular situation. The case theory has always been, they've said it over and over and over in the papers they've submitted to you, Mr. Baldwin didn't check for live ammunition. He pointed the gun, he pulled it, and then Ms. Hutchins died. So they're trying to vary significantly from the theory of the indictment. Problem number 2, causation. Mr. Baldwin not checking for blanks and then pointing the gun did not kill Ms. Hutchins. She was not killed by a blank. She was killed by a live round. And all the testimony shows that blanks are very different from live bullets. If Mr. Baldwin checked for a blank, there would have been no blanks there. And so they have a major causation issue as a matter of law in presenting this brand new theory that was not in the indictment. Number 3, there's a foreseeability problem as a matter of law.
Yes, Sebile.
With their intention to present the
It was a
blanks
live
theory.
round.
The Henley case, as Your Honor knows, we've briefed it for you, says the requisite criminal state of mind needs to match or converge, is what the case says, with the criminal act. And what the state's doing here is they're playing apples and oranges. They're saying Mr. Baldwin had the reckless criminal state of mind because he knew that blanks can kill. That was foreseeable to him. He didn't check for blanks, and then Ms. Hutchins died. But the act that he's been charged with is not, he didn't check for blanks and Ms. Hutchins died as a result of a blank. It's that she died as a result of a live bullet. So they're mixing apples and oranges here. They're trying to take what they say is a foreseeable risk and match it with an act that didn't cause the death. So that violates the very clear requirement of Henley that the state of mind and the act converge. That's not what they're saying here. And then last but not least, there is zero evidence in this case, zero, that Ms. Hutchins would have died, or it was expected that she would have died, if you look at the foreseeability cases, if there were a blank in that gun. The foreseeability cases say it's not what can conceivably occur. Blanks can kill. It's not what can conceivably occur. It's what's expected, what's objectively and reasonably expected. There's zero evidence in this case. They don't have an expert. They don't have a fact witness that can testify. And certainly a fact witness wouldn't be allowed to testify about this, that if Mr. Baldwin had a blank in that gun in that moment, it would have killed Miss Hutchins. Zero. There was no obstruction in the barrel. They keep on saying obstruction in the barrel. There was no obstruction in the barrel. He was feet away, 2 feet, 3 feet, 4 feet away from Miss Hutchins. It was pointed at her armpit. There's nothing in that gun that could have pierced her body. There is zero evidence. If you look back at The Crow, if you look back at the history of motion pictures, there are 2 incidents where a blank was involved in a death on a movie set. In 1984, an actor put the gun directly against his head, and the pressure pulled the trigger, and the pressure from that directly against his head killed him. In The Crow, so very different from what happened here, miles and miles and years apart. Number 2, in The Crow, what happened was the crew was making dummies out of live bullets. And when the dummy was put in to the gun, it still had residual gunpowder. And the primer got hit. It knocked the bullet tip off, it discharged. And then there was a blank loaded behind that live bullet tip from a live bullet that people on the set were making improperly. Still no criminal prosecution there. Said it was civil negligence, not criminal, but that's not the point. The point is, if you look at what happened in both of those cases in the history of motion pictures, they are entirely distinct facts. The state cannot come in at the last minute and say, blanks can kill. Mr. Baldwin knew that, and therefore he had the requisite state of mind, and they match it up with an act that killed Miss Hutchins. Zero evidence that that would have happened here. And therefore, they cannot present it as a theory when there's no causation for it, there's no foreseeability for it, there's no evidence for it, and it's not in the indictment.
All right, thank you.
Thank you, Your Honor.
The Crow is where Bruce Lee's son was killed. Brandon Lee. That was the movie they were shooting.
I'm looking at the indictment that was filed in this case. I don't see anything that says live round. I have it right in front of me. So I'm not exactly sure what Mr. Nickus means when he says, if you look at the indictment, he was indicted for that. I'm looking at the indictment. It doesn't say anything about that. So I want to try on occasion to agree with the defense. I want to try to come together. The issue of, do we want to have witnesses testify about what happened on the set of The Crow? No, of course not. I intend to present absolutely no testimony with regard to, I expect no witness to say The Crow. But here's why this is relevant. The entire defense is Mr. Baldwin had no reason to believe that there was a live round on set. Well,
Is it on set or in the gun?
I think they've argued both. They've argued that he had no reason to believe that there was a live round on set, that he had no reason to believe that there was a live round in the gun. So, and here's what they're going to argue. They're going to say this gun is completely inert. He should be able to treat it like a toy because everything is completely safe. Yeah, but the problem is that these safety bulletins and these rules that the defendant failed to follow were created because real guns on movie sets are dangerous. That's the whole reason they were created. And one of the ways that we know that they're dangerous is because if you combine a blank with a barrel obstruction, you can kill someone. It's not what Mr. Nickus said, that there's no reason to think that it would have killed anyone. It would have killed her if there was a blank and a barrel obstruction. I agree with him that that's not what happened in this case. But the point is, real guns are dangerous. The SAG safety bulletin from the Screen Actors Guild says blanks can kill, underlined, bold, exclamation marks. Mr. Baldwin's state of mind is what's critical in this case, and Mr. Baldwin understood real guns on movie sets even best case scenario for him, we imagine that there's no chance that there could be a live round on set. He still knows they're dangerous, and he understands that the rules exist because they're dangerous. The rules that say, don't point it at anyone.
Why does she
keep
sound like
your
she's
finger off
talking
the
to a
trigger.
3-year-old?
Those are all
Just
the
make your
things that were
argument.
designed
I
because
dislike this
real
lady more
guns
and
on
more.
movie sets, even if there's not a live round, can kill people. Mr. Nickus can stand up here and say blanks don't kill people. They certainly do kill people. And the Screen Actors Guild Safety Bulletin says blanks can kill. So the problem is that
She's
the
not so
defense,
condescending.
the defense theory is this was a completely inert
Hey, Richard.
gun. And the only thing that made it a problem was the fact that there was a live round in it. And that's simply not true. And it goes to Mr.
Doesn't it,
Baldwin's
Arcane?
state of mind. It goes to exactly what the state has to prove, which is that he knew or should have
Sounds like an
known
elementary
of
school
the
teacher.
risk when he pointed
Yeah.
the gun at someone, cocked it, and pulled the trigger. Live round or not, he understood that risk. That's what we
That's
have
all I
to
hear.
prove, and that's what we're going to prove.
Well, it was in the grand jury hearing that you, the indictment doesn't say it. But
Sure.
you did, to get the
Lally's
true
sister.
bill, you talked about live ammunition in a
You
gun.
guys are
Sure,
brutal.
absolutely. And that's certainly a part of this case. And I don't want to pretend that it isn't. Because the other thing that we know, and we put this in some of our responses, is that when Mr. Baldwin was being interviewed by Corporal Hancock, he actually said to Corporal Hancock, I'm wondering if Hannah commingled live rounds with her dummy rounds. He knew that there was a possibility that a live round could find its way on set. He didn't even know that Ms. Hutchins had died yet. And he told Corporal Hancock, I wonder if they were commingled.
Alec Baldwin
He
started writing down
knows
something.
that
And he's
these
passing the
guns
note to his
are
attorney.
dangerous. And listen, the state isn't, I've had countless cases where the prosecutor has a slightly different theory at trial than they did in front of the grand jury. There's nothing improper about that. We're not amending, we're not trying to add charges at the last minute. I don't understand exactly what the issue is. If there's case law that says that I'm married to absolutely every single theory that was put in front of the grand jury, it's news to me because I've had courts amend grand jury indictments in the middle of trial based on the evidence. And the evidence in this case is that this gentleman knew that you can't point a gun at someone and pull the trigger because even if there's not a live round, it might kill somebody. He knew that. And I agree, we don't have to get into what happened on the Crow, but at the same time, the safety bulletins are made because of that. They exist because of that.
Thank you.
A few issues, Your Honor. In terms of the indictment, it was in the grand jury instructions on which the indictment was based, to be clear. There's nothing in the grand jury instructions, in the indictment, in this case, where the actual allegation of the charge is that Alec Baldwin didn't check for blanks, and therefore he's committed involuntary manslaughter. This, in terms of time, Your Honor, and sensitivity to cumulative witnesses and cases within cases, this is a case within a case. It's a hypothetical case about an act that didn't happen, that didn't cause the death at all, with, on top of that, significant questions about whether it's even possible when we know from the history of motion picture, it's never happened in this way. Who are they going to testify? Who are they going to have testify, the state, that Miss Hutchins would have died if there were a blank in that gun? What expert witness is going to say that? They don't have a single expert witness. They don't have a single fact witness who's allowed to testify about that. They don't have any evidence that there was an obstruction in the gun. There's literally no evidence of this. And if they want to put on a theory that merges different state of mind with this hypothetical act that didn't cause a death, then we're going to have a very confusing trial with multiple different witnesses being asked, have you ever been on a movie set where a blank killed someone? Have you ever been on a movie set where a blank shot and pierced someone's body in a way that was really dangerous? Have you ever had someone on a movie set shoot a blank in a way that did anything other than cause a little rash or hurt someone's ears or make their eyes have stars in them. We're going to have a trial within a trial about a hypothetical that was not raised until the very last minute and wasn't the basis for the charge in the first place. They have foreseeability issues, they have causation issues, they have evidentiary issues, and there are major notice issues. And in terms of cumulative testimony and wasting of time in cases within cases, that's what this theory is going to become. Thank you, Your Honor.
All right, thank you. All right, the court makes the following ruling weighing whether it has any tendency to make a fact more probable or less probable than it would be without it, and whether its probative value substantially is outweighed by unfair prejudice. I think it's difficult to deal with what I read in the grand jury transcripts about, the theory about the negligent use of a deadly weapon is just his manner of handling, that he shouldn't have cocked the gun, et cetera, et cetera. And then with respect to the alternative, it is that he failed to check the gun. He failed to confirm that the gun, I remember the word confirm about live ammunition before he pointed it at someone. I think that I will not allow any testimony other than one sentence statement, probably by your expert, Ms. Morrissey, that says that blanks can also kill. But to consider that he failed somehow, that's just going to be up to the trier of fact. I think everybody knows guns can kill. It depends on what's in there, but I think that you can mention it. But that's it. We're not going to go through 5 different questions on tell me how and how serious this is, and if he's a gun owner and he's done all these westerns, or not westerns, but all this gun experience, and he should have known it. Just say that, and if you can tie that up, great.
Understood.
All right, let's take our lunch break.
Lunch
Okay.
break. All right.
All right,
We're going to push
What
you
else
guys
you gonna
to
surprise
Megan's
me
stream
with?
in a second.
exhibits.
And I
What
will
are you
be
gonna
over
do?
there, assuming she's still live.
I mean, because maybe we can have an hour lunch.
I want a real exhibit list from the defense that doesn't list
You
every
don't-
piece of evidence.
They probably feel the same way.
Well, we were pretty specific.
I do think that given the court's guidance today, that there could be, I'm hoping that the opening exhibits all work out, and I'm hoping that this slowly streamlines a little bit to take
The
some
board
burden
here
off.
is 50 minutes max a piece.
You said 50?
50.
Okay.
50.
50.
Oh, let me just be clear on board here. So as you're
Oh,
getting
that's going to
ready
be
for it.
short. It's less than 2
Questions.
hours.
I know I'm looking at you, but he's standing. Questions.
Wow.
Not
I'll
just
do that.
keep standing. All right. No. Okay. You can sit down. Okay. Questions. Not your theory. Your hi. How are you?
She's still live. Thank you.
Questions.
All right.
Okay.
I'll be there
And
in a
the issue
moment.
is fair and impartial. Okay. Not maybe this isn't the case for you. We're not shopping. It's fair and impartial. Okay.
Can you be
and
fair and impartial? Yeah,
questions.
that's
My-
standard.
I meant, I'm emphasizing questions. You ask questions. You don't talk to them. Do you understand what I mean? I mean, I'll give you latitude, but I'll have to pull you in if you're not trying to get fair and impartial.
I'm just wondering in terms of what sent us into individual voir dire during. the
I'm not
two-
going to do individual voir dire.
Okay.
I think this is different.
Oh,
And I'm just,
Well, I'll hear you out. Okay, I'm sorry to interrupt you.
no, and listen, it may not turn out to be an issue, but my only concern is if we start to have potential jurors who say, I don't think that I've seen in the press that he didn't know that the gun was loaded, and I don't think that he should be prosecuted. I think that there was a concern in Gutierrez that if we have all of these jurors just giving their opinions because they've seen things in the press, it kind of poisons the well.
Right.
So
Well,
that's my
first of
only
all,
concern.
my intent is, and I'm open to hearing from you all, but when that happens, I'm just going to call you up and agree that this person should be stricken for cause and he can leave. What do you think?
Sure.
Yeah, it would have to depend on the, how extreme it was, but I think we'll be able to make eye contact, frankly, and figure out some of this. I'm hopeful. Yeah, I don't know how the court, I wasn't there at the first trial, and I don't know how the court is planning to design this. There is, of course, in both directions, a risk of pollution of the jury pool, right?
Right.
So I think that if anybody has, extreme views on anything, maybe that's a way to sort of say that you're going to hear questions. And if you think that you have a view that should not be spoken publicly and you would like to speak to me and the lawyer separately, you can so indicate when you raise your hand.
Right.
And,
Well,
and that,
that's part of my instruction.
Right.
Okay, that you can speak in private. And most people start say, well, I want to speak in private. Or you say, do you feel like you should speak in private? And they'll say yes. I'm less inclined to do private voir dire because it just took so long. And the other thing is that, think about it. I think we're going to have 79 on the panel, and we will be able to know immediately. You're going to get five and 3. Is that right? Yes,
Yeah.
5 and 3, and for causes, and we'll know whether we need a second jury panel by then.
I just want to throw this out there. One of the things that may speed up the process, if we do have a juror and we think that they may have some potentially prejudicial things to say, rather than kicking everybody out of the room, maybe we can just invite that person
Yes,
up
so
to the
that,
bench.
I've done that. Yes, I've done that.
Okay.
I agree that makes sense.
Okay. Was anybody thinking private?
I just wasn't sure.
I think it's easier to do the subset of private when necessary and not invite it at the start. The judges that I try cases in front of always think that if you invite it too early, then it becomes a domino effect. I don't.
They all want to leave.
No, I expect a lot of folks will want to speak in private about this, but
Yeah.
I just, I think this is different, a little different from Hannah Gutierrez.
And will we be addressing the entire group or just?
Yes, 79.
You'll do the whole group with
79.
questioning?
Yes,
Right.
and then if you can't pick a jury out of 79 folks, which I find highly doubtful, then we'll call in the next panel. Okay?
Thank you, Your Honor.
And does the next panel come in that same?
Staggered. Yes, it's staggered. That's why when we're finished with the 79, I want to know if I have a jury.
Okay,
So,
good.
yes, I want to know how many, and we'll know probably by the 4 causes.
Understood.
Okay. All right. Well, and so do you want an hour for lunch, or do you?
So yeah, the only thing that I would say about the exhibits, and I mentioned this before, but perhaps we're getting even further, which is, I've just told them about one part of their case is not going to be necessary, and they disclosed when that witness would be testifying. If the state can even provide some shell, okay, right now we have still have 44 witnesses and 13 experts. Any guidance, I'm not holding them to the guidance. The court need not. I'm not going to ask the court to hold them to the guidance of the gist of the case. The gist of the case and their
Okay.
expected witness, we are going to be able to very, very quickly say, okay, then those lapels, that issue, it becomes irrelevant, and I'm going to be able to deliver to the state what they're going to ask the court for.
Okay, very good. So what we're going to do is we're going to take an hour lunch because we're almost finished with these. And then the court is going to instruct you all to meet and confer about what you all think about your cases and streamlining.
Okay.
Okay?
All right.
All right.
Thank you.
Okay.
All right. We're in
Awesome.
recess.
We're in recess. All right. Okay. I'm going to push you all to Megan's stream, and I will see you all there. Thanks for joining, everybody. I'll see you in a second. Let's talk about some Karen Reed stuff.